It's Tuesday and it is 2/22/22. It is good to see you. It is been a whole day this morning, and I will tell you about that in a minute. Today we are covering a few quick bits and then very few quick bits because we have so much to talk about with these motions for new trial in both the Maxwell case and the Duggar case. And we're going to just go through all of it. We're going to go through all of it. I'm so glad to see you this morning. I'm glad to see where you all are coming in from. It is some of y'all are having wild weather. I get it. We're having wild weather here in Middle Tennessee as well. Good to see you from Canada, Alexandra. And I see you guys coming in from all over the place. It is just so good to see you. So, hello to the UK crew. Hello to the Canada crew. Hello in Mexico. And I saw some of you coming in from the Ukraine, and know that our news is talking about you all the time, and we are thinking of you as well. So, hello, international crew. Let me know where you're coming in from, what you're drinking. And I've just got coffee this morning. We're just doing coffee this morning. It's been a day. I'm going to tell you about it. I should roll the intro. You know what our topics are. Replay crew. Love you. Love you. Everything will be timestamped down below. So for the odd individual that's like, hey, not odd, strange, odd as in like every so often, that's like, your intro's long. It is. There's timestamps. We love to chat. We're law nerds. We're here to say hello to each other. And we're here to talk for a minute about my deep and burning disdain for Ticketmaster. But first, we need to just roll it because we need to get this party started. I haven't even had coffee yet. I'm ready for coffee. It looks like it's 5 p.m. outside because that's the kind of weather we're having today. We're just going to roll with it. Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the Cursey words. This channel is where the law nerds unite to talk about facts, not fuckery. No, a lot of us law nerds are odd. We are nerds. We are all strange. I did not mean odd in that way because I love odd in that way. I meant odd in the one random person that's like, your intro is so long. We chat. You don't get to the point quickly. That's why I put timestamps. I'm aware. I'm aware that I don't get to the point quickly. I'm aware it is long form content. But with that said, I have to rant about Ticketmaster for just a minute because mother fucking Ticketmaster. I love live music. I love live music. And this year I got skunked on the warehouse ticketing, which is, if you are not Dave heads like me, it's okay. I am a giant Dave Matthews nerd. It is a thing. It is my thing. It is a thing. It is a thing. I have seen Dave every year they've performed since like 1996. Even while pregnant and vomiting in a trash can, I was still there. And the kindly folks at the venue were like, "Are you okay?" And I'm like, "I'm just very pregnant." I'm fine. Dave Matthews fans are the best. Love Dave. Jealous of all my friends that were in Mexico to see Dave and Tim. I'm never missing that again, I have decided, but that's beside the point. The warehouse ticketing period ends. I get skunked. So today, also my highlighted version of the last motion we're talking about today will not upload onto my computer, and it is just infuriating me. And I've been trying all morning, and it just might not happen. We might not be able to make fetch happen this morning. So I'm going to keep trying to do that while we're talking. So I get skunked on the warehouse ticketing pre-sale. It just is what it is. Sometimes you win, sometimes you lose. That's okay. So I have a city card to do city pre-sale. It is literally the reason I have a city card. I could give a shit about a city card. I don't care, but they do ticket pre-sales. So today, 2/22/22, I'm like, it is maybe the numerology will help me today get tickets through Ticketmaster for the City Card presale. Maybe all of the good juju or the spinny air here in Middle Tennessee, something will help me get some goddamn tickets to go see the Dave Matthews Band with my friends this summer, so I can just, eat, drink, and be merry, because who even knows anymore? Look, this is where my money goes. It just goes to concerts now. So I get onto the pre. I get into the queue for the presale. First of all, I get queued. After I get through the queue, I get to buy tickets. Half the tickets are not city presale; they are premium presale, and they are literally like 5 times the price of the city presale tickets. But of course, those are the ones that remain. Of course they are. And then it's like, well, what's money anyway but a paper construct of man? So who cares how much? Who cares? I care, kind of. My budget cares. My bank account deeply cares. I'm like, I don't think we're just going to burn money to go see Dave Matt. Yeah, we are. That's what we're doing. But the presale tickets are gone by the time I get through the crew. And I'm like, how many presale tickets were there? 5. It's not like I'm trying to get to one of the most popular venues. I am trying to get to not one of the most popular venues. So the presale tickets, I can see them, and I click on them, and it's like, you've timed out. And I'm like yelling at my computer because it's just like, sorry, go fuck yourself. You're not getting tickets. So the only tickets left are these premium tickets. And I'm just like, why have presale tickets and then this other category of presale tickets? I don't understand. It doesn't make any sense to me. And I'm so frustrated by it. So I'm like, okay. Look, it's just going to be fine. We're just going to get the tickets we can get. We can't get through the pre-saling of the thing. We're gonna go for the fucking premium who cares? We're old, whatever. Money is a construct. We won't hyperventilate about what we spend. It's going to be fine. So then I have to do this again because they release at the time of the venue, not my time. So they don't pre-sale at my time. They pre-sale at whatever 8 or 9 a.m. it is, local time to the venue. So I'm buying tickets on the East Coast, and then I'm also buying tickets for shows on the West Coast. So then I have to do this all again. I'm like, oh my God. So again, get into the queue, wait through the 1,000 people in front of me in the queue, because the location I'm going to on the West Coast is not a location he plays every year, and he skips it some years. And it's very important to me to be undercover because it's going to be very hot in September. So I know where I need tickets. I am not doing the lawn. I am too fucking old. I don't want to be in the pit either. We're not doing general admission in either. I just need some seats. It's fine. So I go through the whole queue, and again with the premium tickets. So I finally get 4. I know I was asking for a lot. I was asking for all of the stars to align to get 4 tickets in a presale. I know. Big dreams here, people. Big dreams. I just want 4 tickets to dance with my friends that have known me since the 90s. That's it. That's all that I want. I want to drink some vodka lemonade, and I want to go see Dave Matthews, and I want to be sweaty and hot and have a good time. So then I go to check out. I get the actual city presale tickets. They are not outrageously expensive. And then there are $120+ of fees for each ticket. And I almost lost my mind. I'm looking at the cost of the tickets. This is still not uploading. It might just not happen. I'm looking at the price of the tickets going, I can deal with this price of tickets. And then we get to the fees. And I'm like, are you kidding me? Where are they Where are the fees going? Over $100 in fees. Where to where? And then there's a delivery fee. And I'm pretty sure we just covered the Brittany Dawn lawsuit, wherein the state of Texas was like, you can't charge shipping for an email. But these are virtual tickets. So I now need to know the legality of the delivery fee for the virtual tickets because I'm mad and I feel like it can't actually be legal. So this is my next deep dive into how we got here and how this is legal. Like, how is this okay? How is this okay? And you guys are like, surely that's per the $120 for four. No, no, it was a like $98 venue fee, and then there were like 3 other fees, including a processing or delivery fee. And I was like, I am going to go through these fees with a fine tooth comb. I have got questions. I need to see if there's been lawsuits. So we're going to have to do a deep dive on Ticketmaster and Live Nation because I am now angry. I don't understand. How is there a delivery fee for virtual tickets? It's not a shipping fee, but it's a delivery fee. How, what, why, how? I'm so mad. I'm so angry. So lawyer Emily's like, we're going to do a fuck you Ticketmaster stream at some point and just deep dive into all of these fees because how is it okay? But at the end of the day, see, this is the thing though. They count on you being like, but at the end of the day, I get to go see Dave Matthews this summer. And I love Dave. But oh my God, the internal rage. Oh my God, the internal rage. I could not believe how high the processing fees were. It's it is 2/22/22. I'm going to manifest something better than this today. We're going to release the rage. I'm really glad today's video is sponsored because it's probably going to get demonetized. And at this point, I need the money to pay for Ticketmaster fees. We just do. There's no way around it. It's just the Ticketmaster fees have gotten out of control. And I'm so angry. But I'm really glad we have a sponsor. So I'm going to be doing a deep dive passion project of tickets. And it also makes me sad because live music is I firmly believe, and y'all can disagree. You're welcome to disagree. You might be wrong, but you're welcome to disagree. I think live music is good for the soul. Now, I understand that not everybody loves a large concert, a stadium concert. I get it. Sometimes it is somebody playing the guitar when you land at the airport. Yes, they do that in Nashville, or they did pre-COVID. Live music feels different. It's incredible. It makes you feel good in your soul. You connect with your other humans. It is just one of my favorite things. And I don't think live music should be at the cost of like $500 or $600 per ticket. Like, what is happening? You should be able to afford to go to concerts without these fees. I mean, what are you doing for the fees? I want to know where the fees go to. How are they apportioned? Has the FCC looked into that? I need to know. So I'm going to be doing a deep dive into the fees. If they can be like, look, these are all the fees that account for safety at the venue and all of this, I want to know. I just want to know. I have a lot of questions. I don't have answers. I need to know. I am done ranting now. I am sorry. I am very riled this morning by the amount of money that I spent for fees. I don't mind paying for tickets to see my favorite band, but how much does my favorite band even get from ticket sales? I've got questions. I want to know. I need to find. Look, artists talk about how little they get paid, and I want to know, like, I am paying that premium to see a band that I ride or die for. But how much is that band actually getting? So I'm just like, we are going to have to talk about it. I know there is a long history there of bands that have fought with Ticketmaster. I feel like they have a monopoly, but that's just a gut feeling. These are all the questions I have. I have a list of questions because I was so pissed off buying tickets this morning. This is why I do better when I do warehouse presale. I just buy them through the band and I'm like, okay, we're going to breathe. But today, the whole process was just a mess. And then they all still end up on scalper resale anyway. Like, what bots programs do they have that they can buy tickets and then raise the price again and then So Celine's asking me if I've checked SeatGeek. No, because these are presale. So they have not gone on sale yet. These were, when they get to SeatGeek, they're more than what I paid for them today because these are presale be the city, they might be on there now. These were the city pre-sale before tickets go on sale on Friday. So tickets for Dave Matthews go on sale on Friday. We tried to get them early today. I have got to see if I can get this this motion up while I talk about a few other things, because I am so annoyed that it's not pulling up. I'm just like, I read it, I highlighted it, but we have other things to talk about. I'm going to switch to a little, well, we're going to switch to our quick bits. So we should just, we're going to take a deep breath. We're going to take a deep breath. We're going to go to quick bits. Quick bits. It's time for quick bits. One of the things I've been asked about quite a lot on social that I'm not going to cover, that I'm going to tell you why I'm not going to cover, is everything that's going down in Canada. And I have said it multiple times on this channel. I am not a political commentator. And the reason I'm not a political commentator is because I don't love it. Politics has gotten very, very polarized. I find it very hard to have conversations where we can get down to the facts and then get out of the all of the polarization of it. And when it comes to other countries, I don't have the context that I need to actually bring commentary in a way that would be helpful. I can't break down what's going on because I don't know. I don't know the history of the political parties in Canada. I don't know the history of Canada's constitution. I couldn't name all the political parties in Canada. My heart is with you because what I see and what I've been watching is tremendously stressful. And I think that all of the residents of Canada have to be feeling crushed by the weight of the stress of what's going on in their country and the pull apart of what's going on in their country. So all I'm going to offer and share is how I parse things that I am watching go down when I want to understand better and don't, and B, when I am not really sure what the whole story is. The way I parse things, like I parsed January 6th here in the US, was first of all deciding or evaluating what my feelings were on it. Like, how am I feeling about this? And when I'm feeling like all the feeling, like I'm feeling about Ticketmaster, my brain does not work the same when I am feeling. And so I parse my feelings first. Like, I'm feeling mad, I'm feeling frustrated, I'm feeling sad, I'm feeling confused. I parse that first. And then I try to put that aside and go look for different viewpoints if I want them and try to get to what the facts are. And then when I look at what government actions are doing and where governments are taking action, I try to look at what they are taking, what action they are taking, if I understand if they're legally able to take that action or not. And then I always run it through the viewpoint of, if this was happening to a cause I didn't like, how would I feel? And if this is happening to a cause I do like, how do I feel? And that's really how I parse the facts from a situation, and that's how I parse how I feel about it. But this channel is a spot to talk about the law and to talk about the pop culture of the law. It is a break. It doesn't put to the side how much heavy stuff is going on. There is so much heavy stuff going on in the news. There is so much heavy stuff going on in the world, but we are going to stick to the pop culture because A, that is what I like to cover, and B, that is where I think I can actually be of help to parse what's going on in these cases, because I have enough context. And if I don't have context, I can say, hey, I don't have context for this, but let's go through these motions. And that is why I like going through legal filings the most, because at least we have one side of the story down in writing where we know what's happening. So it's not that my heart's not with you. It's that I am not a political commentator and I don't have the context to give the commentary that I would want to give. When I studied politics in college. I was a political science major. I studied political statistics because, again, I liked looking at something tangible. I liked looking at the numbers. I liked looking at how things parsed out. I liked looking at how different counties voted. I liked having something solid to work off of. But I also had the context of growing up in the US and of wanting to deep dive into the history of how US politics grew and changed, how our Constitution grew and changed, and how our laws came out of it. And I don't have enough background for other countries. I did not focus on international laws and relations, and I don't want to do a disservice by not understanding enough of the context. So, with all of that, that's how I parse information. My heart is with you. I can only empathize with the tremendous pull and heaviness and weight of watching what's going on, that the people in Ottawa must feel like they're stuck in the middle of something that they never signed up for. It's like I am stuck in the middle of a pissing match between two sides, and I didn't sign up for this, and I am maybe not here for it. So I have watched Simply Neological. She has a podcast where she and her husband Ben, who are residents in Ottawa, talk about their experience. I've watched things from Viva Fry, who talks about what he's seen on the streets and his experience. They have different viewpoints. I would just challenge you, if you feel strongly one way or the other, if you can, to look at the other side. And if you can't, know that it's okay to take a step back from the news cycle and say, I can't do that today. It's okay to take a step back. And it's okay to take a step back. So with that, I am going to go into the rest of our quick bits, but I've been asked a lot about it. It's like, why aren't you saying anything? And it's like, other than this must be tremendously stressful and this is how I parse information, there's not much more I can give that would actually be of service or helpful or informative. And so there's no point in me just, spinning on feelings, because that's not what we're here to do on this channel. So there are plenty of Canadians that are chatting about it. I encourage you to go find the Canadian sources that are talking about it and look at them. There are Canadian lawyers here on YouTube. There are Canadian commentators on Twitter. You've got Canadian creators like Simply Neological talking about their experiences. And that's why. But I also want to be upfront with you to say, this is why I don't cover these things, because I can't know enough to do it justice. And I hate it when people just pontificate on things that are so deeply serious. I will pontificate all day long about what Erica Girardi knew about some earrings. But at the end of the day, that has far less significant import to geopolitical climates than what's going on in Canada. And it's just not something I can be light about. So I'm watching. I just can't offer much because I don't know enough. And I think that's the important part about being a commentator, is knowing when you don't know enough to comment on something and saying, I just don't know enough. I have questions. I have questions about how what's going on in government works with the Charter and the Bill of Rights. I have questions about that. I don't know the answers. But those are the questions I'll keep looking at. And it's not that I don't love our Canadian viewers. Y'all have way better chocolate than we do. And poutine. So we love Canada. It's just, I don't have enough context to be of help. And with that, we're going to talk about Wendy Williams real quick. It looks like there are numerous reports that the Wendy Williams show is going to end in June, and that Sherry Shepherd will be taking over her own show in the fall. I'm sad to see it. I don't know if what's going on with Wells Fargo fed into this, but it's something that I'm looking at. Did Wells Fargo's motions for conservatorship and freezing her accounts, did that have something to do with the show? Because in the motions Wendy Williams filed before they all got sealed, and look at this, they sealed everything. I ranted about this last week, but they sealed everything, and I hate it. Why did you seal everything? You could have redacted documents. But no, they sealed literally everything. And we talked about this last week when they did it. We've gone over these. If you want to see them, we went over these on our channel, and those videos are staying up. Unless by force of court, I am required to take them down. And even then I will kick and scream because I don't think the court has jurisdiction over me. But with that, they sealed this on the 16th and there's been no further docket entries. I just don't know if what's going on with Wells Fargo played into this, because in Wendy Williams' motions, she said that, well, through her lawyers, whenever I say she said, it's through her lawyers, said that they weren't able to meet payroll with all these things frozen. And I just worry that this all played into it and that this has caused greater detriment to Wendy Williams as a person. And it just makes me sad for her that the actions of Wells Fargo may have, and this is, again, I don't know. I'm concerned that this may have caused further detriment to her, and that makes me really sad, truly. So with that, we need to get to we need to get to our sponsor, and then we need to get to the rest of the quick bits. You guys, when I tell you that I don't do a lot of these types of sponsors and game sponsors, I have to know that it's something I enjoy. I very much enjoyed this, and it has taken up a lot of my time. So the world is very heavy right now. And if you are looking for a magical little escape, let me introduce you to something that will take up way too much of your time and you might very much enjoy, because I do. A huge thank you to today's sponsor, Switchcraft. Switchcraft is a story-driven match 3 game with interactive story set in a mysterious academy of witches. It's really beautifully drawn and it's a lot of fun to play. I love a casual game and it's a vertical gameplay experience. Look, I love that about this game. It's real easy to just swipe your spells and your matches. But it is a brand new take on match 3s, because not only do you get to play the match game, but you also unlock pieces of a beautiful, magical, and gripping graphic novel where you have elements of choose your own adventure, because you get to pick what your character says and does and reacts. And it's really fun to see how it changes the response in the game when you choose what your character says. You will want to keep playing to see what happens next. And Switchcraft is one of the few truly diverse casual games that's rich in narrative and offers a contemporary view of magic and witchcraft. It is magically fun, and I think you will be charmed by it. I know. Bring the dad jokes, Emily. I did. Download Switchcraft for free to unlock the magical mystery. Thank you for sponsoring this video. Let me know what you think of Switchcraft on social, and if you're having fun playing along, you can just download Switchcraft for free. It really is magically fun. It has spent a lot of my time. When I say a lot of my time, I mean a lot of my time. All right. With that, our next quick bits is there's a final judgment in the Cardi B Tasha K case. So let us talk about Cardi B and Tasha K real quick. I know, something defamatory. We've got to talk about defamation. I would like to talk about things other than defamation. I think we're going to get to copyright and crypto and NFTs and OpenSea. We'll get there on a different day. But for today, let's look at this final judgment in this case. They reduced some of the award. So with reducing some of the award, here we go. So final judgment. This means they can start attaching assets and property now that a final judgment is entered. The jury having returned its verdict in this case in favor of Cardi B on her claims against both defendant Tasha K and her company, the court hereby enters judgment in favor of plaintiff and finds that defendants are liable for defamation, invasion of privacy, false light. And again, if you guys watch, comment on this. Invasion of privacy, I think some people see it differently, and invasion of privacy, false light is reputational. It's casting someone's reputation in a false light. So it's not invasion of privacy like busting into somebody's house or getting into their emails and things like that. I think there's misconceptions with invasion of privacy, false light, but it's casting someone's reputation in a false light. And intentional infliction of emotional distress. The jury awarded plaintiff $1 million for pain and suffering and reputational injury, $250,000 for medical. The parties, by stipulation, the parties agreed that they were going to reduce the award of medical expenses from $250,000 to $25,000, and that the stipulation does not violate the defendant's ability to appeal. So the stipulation is, hey, we agree that the actual cost, because that's an actual cost determination, the actual cost of medical is $25,000, not $250,000. What we see is that this jury was just like, fuck it, give Cardi B the money, give her the money, give her the money. We're done. Just give her the money. And so they were able to reduce that. The jury found that defendants are jointly and severally liable for those damages, meaning joint and several liability means that Tasha K as an individual or her company both have to pay. So it's not that the company has to pay and she doesn't. They both are responsible for it. So if the company can't pay, she personally has to pay, which means her assets, both business and personal, home, etc., can be attached. We've talked about this a lot when it comes to the bankruptcy of Tom Girardi. It's one of the things the Rigomez family did, is that they went and attached all of the properties he owns. So if he goes to sell a property, they get their money first before any proceeds of sale go to him. So this judgment allows the attorneys for for Cardi B, should they choose to attach the property of Tasha K, house, and other things like that. So it allows them to start enforcing or seeking to enforce the judgment, though we know from statements made by Tasha K that she says she is appealing. The jury found defendants are jointly and severally liable. We talked about that. The jury awarded plaintiff $1 million in punitive damages. Remember, punitive in the Launer dictionary means punishment. They're the you suck damages. Punitive are the like, punishment, don't do it again damages. I like punishment better because it has a P and it makes it easier to stay on track. Punitive punishment, it makes sense. And then $500,000 in punitive awards against the company, $1.338 million for litigation expenses. That's the money that Cardi B actually spent on like lawyers and motions and stuff. Sorry, you're watching me get distracted by the rain. It sounds outside. I'm sure you can't hear it on my mic because it's directional, but it sounds outside like my house is going through like a car wash. That's how it feels. It never rained like this where I lived before, and I'm still thrilled by it. Accordingly, judgment is entered in the amount of $1,025,000 for pain, suffering, and or reputational injury damages. So this is that first part with the reduced award for $25K instead of $250. $1 million in punitive against Tasha K, $500 against the studio. So 1.025 plus $1 million, so that's 2.025 plus 500,000, so that's 2,525,000. And then plus the 1,338. So that's where I'm out. So what, almost 4 million. So that's where we're at with the final award. It's that one plus that one plus that one plus that one. So this allows them to move forward. And I see some of you asking in the chat, does Tasha K get to keep her channel? Interesting that you should ask. I don't know. But there is a hearing set for April 1st for injunctive relief. And I'm very interested to see what injunctive relief will be requested. That might be keep my name out of your mouth. That might be you're not moving forward with this. It'll be interesting to see what the injunctive relief sought is. I will see if I can attend that and see what happens in court, because I'm interested to see. Now, this is strategy on the YouTube channel for Tasha K's lawyers. Not Tasha K's lawyers, Cardi B's lawyers. Cardi B's lawyers, because I'm about to switch gears and talk about Tasha K. My brain is just like, bleh. For Cardi B's lawyers, they are going to have to decide if they want to try to have her channel taken down actively on their own. YouTube could decide that with this, that there are community violations. That's on YouTube. YouTube could enforce this separately. But for Cardi B, they have to decide whether they want to go after her channel. If that is her sole source of income and the goal is to get paid, then going after her channel strategically might not be the best idea. And that might be why we are seeing injunctive relief. Injunctive relief perhaps being Cardi B seeking an order in joining Tasha K from talking about her saying these things, taking down videos, those sorts of things. So that would be very interesting for me to see. I'm just wiggly today. That'll be interesting to see what that injunctive relief is. So we will circle back on this. There has been no notice of appeal filed yet. I know that Tasha K has made statements that she intends to appeal. If she appeals, I will pull the appeal and go over on what grounds she's appealing and give you my thoughts on it. We did not get to watch the whole trial. It was in federal court. I don't know if there were things that we're going to look at and go, oh, well, that's an appealable issue here or there. I don't know. We didn't see the whole trial. I have not read the whole transcript. So until we see that, it's kind of hard to comment on. Oh my God, it's so loud. The rain is so loud. I'm so distracted. I love weather. God, I'm such a nerd. We have an at-home weather station that I love seeing, like the rain accumulations for the day and how hard the wind is gusting. It's just my favorite. So that's what's going on with Cardi B and Tasha K. We'll see what the injunctive relief is. We will see if and when Tasha K appeals and what that appeal is based on. It has to be based on something. And then we will just keep an eye on it. We're not done at this point. The litigation is going to continue. And I'm really curious what comes from here. I've seen, and I'm seeing you in the chat asking about insurance. Defamation most of the time counts as intentional. Not all business insurances are going to cover that. So whether or not there will be insurance coverage on this, I think is not a foregone conclusion. I think it's questionable because it's intentional. It's an intentional tort. And a lot of business liability insurance doesn't cover things that are intentional. So we will see. It depends on an insurance policy. That is a general overview, but it depends on an insurance policy and how it's written. So we should move on. Should we do Maxwell first, then Duggar? I feel like we should just do Maxwell first, then Duggar. Maxwell has more motions, but they are less in depth than the Duggar ones. And this Duggar motion is still just not, it's just not uploading. I'm so annoyed. Hold on. I'm going to try one more time to get it out of my well, not my notes app, but Good Notes, which is what I use to highlight things, because I really would actually like my highlights. It would be so helpful. And I don't want to sit here and be like, I highlighted things. So we're going to things I tried to do before stream, but Ticketmaster was ruining my morning. Emily, you could have done it last night. Shh. Yes, I could have, but I didn't because I was reading it last night when my kids were playing Mario Party. And let's see. Let's try to do it one more time. I wish I could talk more and do things at the same time, but my brain is like, no, girl. All right. Hopefully this one will upload. Are we uploading? For the love of live streaming. When you know it's live, it's live. Let's talk about what's going on in the Maxwell case, shall we? Oh, it just won't upload. I'm going to try to do it one other way in a minute, but we're going to talk about Maxwell first, and then I'll get back to fighting with technology. Fighting with technology. Let's talk about the Maxwell case. I'm just going to go by Maxwell. I'll swoop and then I'll disclaim. Disclaim. Here's why I'm disclaiming. One, I like being a creator on YouTube, and there are some words that YouTube's robots don't understand or necessarily in an educational context. So I will be for both of the next two topics, because both of them deal with horrible things done to children. I will be moderating some of that language the best I can. Does it annoy me to do this? Yes. Do I still try to stay in the good graces of YouTube because I like working on this platform? Also, yes. Does the name Maxwell automatically mean that the robots are going to be angry? Also, yes. But I also don't want to trigger anyone that has not just experience personally or life-wise with all of these things, but there is a lot here that may be personally very triggering, and I understand that, I respect that, and I don't want to to trigger in a way that you can't under hear and listen to what's going on in this case, because I think what's going on in the Maxwell case is very important. Why? Because there is fuckery afoot now. Fuckery afoot in the Maxwell case. I'm going to try to summarize. There are a ton of new motions. Here is the most basic rundown of what happened. Maxwell got convicted. Good. Maxwell got convicted. And we actually now have the verdict forms. Yay. Because the court attached those to an order. So we actually have the full verdict forms and some of the jury questions and things like that. So we're going to go through that first. But she was convicted. After she was convicted, a juror came forward and shared their own experience with grooming, an essay, and those types of things when they were also a child. They shared in their interview that they helped other jurors understand why victims might not do certain things, say certain things, act certain ways. I think there's a preconceived notion, and I agree with this. There is a preconceived notion about what a perfect victim would act like, and it's like, well, they didn't do this, and I think they should. But people who have been through that can say, well, in my experience, that's different. And in my experience, that doesn't always go like that. But there are jury questionnaires that asked about these things in depth. And I did a video on the jury questionnaire. So if you'd like that, it's in the playlist for Maxwell, and goes over what the jurors were asked. This juror said that if they were asked about that, they would have answered those questions honestly. But the government brought to the court's attention almost immediately, hey, this is a problem, which is very interesting to me. They didn't wait for the defense attorneys to say, hey, we saw this juror's interview and we need to bring it to the attention of the court. The prosecution brought it to the attention of the court, which I think shows a degree of ethics that I appreciate. It is appropriate to do so. What I interpreted, this is my interpretation, my speculation, is that when the government saw that interview and saw those statements, they went back and looked at the jury questionnaire. This is my interpretation of why they filed this with the court. They went back and looked at the jury questionnaire and went, yeah, juror 50 didn't say anything about this on their juror questionnaire in a way that we or the defense would have inquired about it more. The thing with the conviction is convictions can be overturned, acquittals cannot, but convictions can be overturned. And if a juror did not disclose and that impacted the verdict, which there's a reasonable belief that it might have impacted the verdict because the juror said, I helped other jurors understand before we came to a guilty verdict, then it is a big problem for the defense attorneys, and that is an appropriate big problem. So what that juror disclosed is unknown, and that is one of the things they are fighting about in court right now. But if the juror had disclosed things similar to what was said in the interview, I believe the government never would have brought it up because there would be no purpose. It's like, yeah, we knew this. We inquired about this. We're good. The only reason to bring it to the court's attention is because it wasn't disclosed. That's the only reason to bring it up. I can't see another reason to bring it up. So we're going to look at the jury verdict forms. We didn't have these previously, and we're going to look at some of the juror questions before we get into this more deeply, because I find it interesting. This is the first time we've seen this because they weren't filed before, and the court just shared them on February 4th. So much has happened in this freaking case. So much. Oh, I left something out. So when I did the breakdown of this first, you'll see it. It all happened very quickly in time in January. Juror 50 has since filed a motion that we will get into in a minute, sort of because it's under seal. So we're not going to get all the way into it. But let's pull up what the court filed. This is from February 4th. There are 3 different things going on, so I'm going to try to parse them and condense them so we can follow along, but there are, like, 3 different tangents of things going on in court right now with this case. The thing that I am most focused on is what's going to happen with the motion for new trial in Juror 50. There are other things about redacting and sealing that isn't relevant to that, and so for now, it's to the side of our conversation because we can't, well, and don't need to do it all. So this is the court's order from post-trial housekeeping. Literally, post-trial housekeeping. It's so funny because in my notes, I always put like a housekeeping at the beginning, like, this is what we need to talk about in this stream. This is the stuff I need to remember to share, blah, 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 blah. And I always label it housekeeping. The judges I worked with always labeled it housekeeping. And it's funny to see other judges do the same thing. It gives me a giggle. It makes me feel like part of the crew still. It's like, oh, sometimes we just all do things the same way. Post-trial housekeeping with exhibits and redacting the exhibits and making sure that the redactions are consistent and making sure that victims and witnesses are protected by the court's anonymity order. There is one victim witness who they went back and forth on disclosing their last name, but that individual had come forward and given public interviews after their testimony, so they've already been disclosed to the public. So it was determined that there didn't need to be additional redaction because that person had already shared who they were. So this is going through jurors who proceeded to voir dire. So after they went through the questionnaires, this is the list of the jurors they picked from the questionnaires. Again, they didn't automatically weed out juror number 50, which again leans towards there was not a full disclosure to the point where the lawyers were like, oh, we understand what's being disclosed here. So this is a list of the numbers that jurors that proceeded to voir dire. You can see how many there are. Let's see. We'll get to the last number. 690. They sent these out to over 600, probably 700 or 800 people, possibly. But at least 694, because that's the last juror that got selected. 231 jurors came in for voir dire. Then they listed the names of the jurors for voir dire. They went ahead and redacted the jurors that were selected. These are the list of locations that they would have read to the jurors. Are you familiar with any of these locations? List of entities. Hey, are you familiar with any of these entities? Including Mar-a-Lago. And then they were asking about a television program. I don't know which TV program they were asking about. I would need to go look. I'm sure it had something to do with Epstein. There were several. These are notes from the jurors. So this is like we're leaving at 5:30. Thanks. I love seeing how jurors write things, and I love seeing that different jurors have written things. It's just so interesting to me. We would like the transcripts testimony of June, Annie, and Carolyn. The juror would assign their name and put their jury number and then the date. So they were looking for a reread of all of the testimony of three of the victims here. So this would have been the 4-person then, because now we're at the what looks like the same handwriting. For the official questions that become court exhibits. Hello, Your Honor. We would like the FBI deposition referred to by the defense during the cross-examination of Carolyn. Thank you. So they were going through, it looks like, Carolyn's story. This is from that same day, the 21st. Hello, Judge Nathan. We would like to end today at 5 p.m. Deliberate from 9 to 4:30 tomorrow and have lunch at noon if possible. Thank you. I love the diligence and respect. We would like to please have our lunch at noon. Thank you. Hello, Judge Nathan. Can we consider Annie's testimony as conspiracy to commit a crime in counts 1 and 3? Thank you. So the court likely would have pulled them back in and reread those jury instructions without giving more of a specific answer. Hello, Judge. May we please have the following testimonies in a binder? We would like them in another way. Probably not. They need to be read in court. June. I think that says Jane, June, Kate. Thank you. from December 22nd. Hello, jury. Is this from the judge? Yes. Hello, jury. If your deliberations are not completed today, do you wish to deliberate tomorrow, Thursday, December 23rd? Please check yes or no. I'm dying. I'm dying. I'm dying that they didn't just take a poll. I love that they did it all in writing. This all needs to be on the record. I'm living for it, but I love the check yes or no. It's great. Please check yes or no. If yes, what time would you like to deliberate? None. We would like to be off. And we know they didn't deliberate on the 23rd and took a break over the Christmas holiday. Good morning, Judge Nathan. May we please have the following items? Different colored Post-its. Shit. They were getting into mapping things out, which I love it. Different color Post-its. I once walked into a jury room after trial and they hadn't erased the whiteboard and they had like lines and like a graph and like a breakdown on the side. It was fascinating to see how actively they had worked through that particular case. It really was. And so I love seeing that they are asking for things to work through this case. We need some different color poster notes so we can make a board. We need a white paper board. We need highlighters, different colors. We want to highlight the transcripts and we need Matt's transcript. We have questions. They also want a different definition of, may we have a definition of enticement? Good luck with that. We've read the jury instructions. If you want to see the jury instructions in this case, they are on the playlist. May we also have, how many transcripts do y'all want? They're like, we want all of the transcripts. We want to go over it for ourselves. I'm loving this. Hello, what an active jury. Hello, Judge Nathan. May we please have the transcript of David Rogers? Thank you. Hello, Judge Nathan. Under count 4, these are specific questions of law. So there was questions about whether they were able to come to agreements and stuff. It's interesting seeing where they were having disagreements. Now, here's the thing. The judge, when all of these questions come in, the judge and the lawyers have to get together and sit down and decide how to answer them, unless it's for things like office supplies. Then it's like, bailiff, take them back. It's very interesting to see them asking for definitions and more explanation, because it seems like they're trying to split. If I was the attorney reading this, I'm like, they're trying to resolve a difference of opinion or a disagreement about something. And the court can't tell them how to do that. So let's look at what they asked and then we'll go from there. Hello, Judge Nathan. Under count 4, if the defendant aided in the transportation of Jane's return flight, but not the flight to New Mexico, where the intent was for June to engage in sexual activity, can she be found guilty under the second element? These are the types of questions that the judge can't say, yeah, nah, sure. This is where you've got to have the attorneys come together and decide on how to answer. And generally the answer is rereading the jury instruction and saying, this is the jury instruction on that element. But it also tells me that the prosecution didn't break this down well enough for them. What the prosecution needs to do in their closing is, and they might have, and the jury just might not have resonated with it, is to go through each count and the elements and say, this fact meets this element, this fact meets this element, and walk them through how to make these decisions based on their accurate recitation of the law. And then the defense comes up and goes, actually, no, that's not enough. So they had a question about one flight, but not the other with regard to transportation, which means this is a jury that was paying attention and was very active in trying to come to a verdict, which I like to see. I also think it's important to go over this for all of you that are like, why are we going over this? It's important to see how jurors work through things, and we don't always get a peek behind the curtain. This jury's notes helps us see how this jury was working through deliberations, and I find the workings of juries fascinating, and I hope you do too. Judge Nathan, we would like to end deliberations today at 5 p.m. Thanks. Dear Judge Nathan, this is the next day. Our deliberations are moving along and we are making progress. We are at a good point and we would like to end today at 5 p.m. and continue tomorrow morning at 9 a.m. Thanks. Good morning, Judge Nathan. I don't know. This must have been stamped on the paper because there's 2 notes here. Interesting. Good morning, Judge Nathan. May we please have the following transcripts? And then it gave a name that's redacted. So Sean, I think this is Kimberly, Elizabeth, Amanda, Jason, I think that's the one they asked for before. Also, may we have clarifications? No. May we have clarifications regarding our schedule going forward? Are we required to continue deliberations every day, including 12:31 and 1:1? Do we get a break for the new year until we reach a verdict? We ask in order to plan our schedules accordingly, which is diligent and respectful. I like that. We are requesting the transcripts of the expert witness on memory. So this is, again, how are we going to determine these things? May we please have the Larry Visick? They asked for the entire trial. They're like, we saw it once live. We took notes, we listened, we saw it once live, but we just want all of the transcripts. The court reporter must have been losing their mind because this was a long trial with a lot of testimony, and the court reporter has to put together a readable transcript for them to read, and normally that takes time. But this is wild, the amount, this is wild, just the amount of transcripts they're asking for. And that was the last one. All right, on December 29th. Here's the verdict form. And we went through the verdict form, but this is the final verdict form where we've got their check boxes. I don't think we had this before. Count 2, this is the enticement to travel that they weren't sure on the flights on. So whatever answer they got, it didn't clarify this for them, or it did clarify for this enough that they were like, okay, we're not there. Let's see, count 3. Count 4, count 5, count 6. And the 4-person, 12:29, 4:44 p.m. is when they came back with their verdict. So those are the verdict forms. And with that, we are going to go through what's going on now. Because it's a lot. So let's see how to parse this the best. On January 5th, Juror 5's attorney filed a notice to appear. So they had an attorney. On January, what was that? On January 10th, there was a motion from Juror 50 that was filed under seal. So let's get to that first, because this is still ongoing, and this plays into some of the other things. So this is January 12th. Counsel for juror number 15 has submitted a motion to intervene and to be provided a copy of the juror's complete questionnaire and voir dire. So a transcript of what they were asked in court and their jury questionnaire, because the jurors don't get to keep that. The attorneys have it, the court has it, but this juror's lawyer does not have it. The motion has been submitted via email to allow the parties the opportunity to propose and the court to consider any necessary redactions. The parties are ordered to submit via email any proposed redactions before January 13th. The parties shall respond to Juror 50's motion on or before January 20th, and then we will go from there, because the court then reverses themselves. The court's like, I changed my mind. So the court changed their mind. This is from January 14th. This is from the judge, Allison Nathan. And the judge said, the court required the parties to indicate whether Juror 50's motion to intervene and to be provided a copy of the juror's completed questionnaire and voir dire should be redacted. In response, the parties have submitted letters to the court indicating their differing views on whether Juror 50's motion should be docketed at all. Should Juror 50's motion be heard at all? So Juror 50 is saying, I would like to intervene. And the lawyers are like, we're not there yet. Like, you need to sit down. We're not even there yet. First things first. And the court has now said, okay, first things first, And I appreciate that the court went back and said, you know what? I'm listening to the attorneys that did this trial. And in listening to the attorneys that did this trial, I've changed my mind. Upon further reflection, the court concludes that it must first address the threshold question of whether any inquiry or whether an inquiry is permitted and or required before considering Juror 50's requests. And I think that's the appropriate thing to do. And I think the attorneys pointed that out. And I appreciate not all judges would take what the jurors said and then go, oh, you're right. Upon thinking about this further, let's do it that way. Not all judges would do that. And it's the sign of a good judge. Judges don't know everything. And when they listen to the input of the lawyers and can either say, no, that's not what we're doing, or yes, that's what we're doing, it's very helpful to see them go, you know what, you're right, let's do it this way. And I appreciate that. It's the sign of a diligent judge, I think. That's my opinion. Accordingly, the court will not consider or act on Juror 50's request to intervene and to be provided a copy of the questionnaire and voir dire until the court receives the party's briefing on the appropriateness of an inquiry. So the court's like, we need to back up. Step one, is there an inquiry of this juror? If there is an inquiry of this juror, meaning we bring this juror in and have to do an inquiry about what the fuck happened to consider a motion for a new trial, then we will consider that juror's attorney's motion, which was filed under seal. The court will maintain Juror 50's motion temporarily under seal until the court considers the parties' arguments. Consistent with this, and to lessen the burden on the parties in the court adjusts the briefing schedule as follows. Remember what I told you to do 4 days ago? Just kidding. Let's do this instead. And then they change the briefing schedule. Finally, in an abundance of caution, the court assumes that while these issues are being briefed and resolved, the parties are in full compliance with the law of the Second Circuit requiring notice of the court's permission before any contact with jurors. Don't y'all go talking to the jurors without me. Don't you forget about, the Second Circuit's rule. Don't you forget about the Second Circuit's too long. It's got to just be me. Don't forget about my rules up in here. Then something that got completely overlooked in the media cycle of it all, a sentencing date was set. Yay! Sentencing. It's going to be 100 years before we get to sentencing in June. It's set for June. You know why? Because there is so much that has to happen before sentencing. So they are pausing the pre-sentencing investigation and report until April because I think, Emily interjection, I think the court is not asking for that to happen till April because the court wants to resolve this issue of Juror 50 first, because the court does not want to waste the time and money to do a pre-sentencing investigation if a new trial is going to have to be granted. And I think that is still a very, very real possibility here, which is why we're going through all these motions. But wait, there's more. When I say, but wait, there's more, hold on. Let me just show you my list of recent motions. This is my list of motions that has happened in this case. This is my note keeping. Yeah. Yep. So they set a sentencing date. That was on January 14th. On January 19th, Maxwell submitted her motion under seal. Hey, Your Honor. Counsel for Maxwell filed motion for new trial and accompanying exhibits under seal. Great. Thanks so much for that. So we can't see it. So then the Miami Herald was like, oh, fuck no. What we're not going to do is file this under seal. So then the Miami Herald was the first one at it, which is why we're talking about them first. The Miami Herald said, hey, remember us? We're the media. Hi. We'd sure like to know what the fuck is going on. Could you maybe just allow us to see? Because redaction and under seal should be narrowly construed. Courts in New York in the Wendy Williams case, narrowly construed. You can redact things, sentences, paragraphs, but sealing the entire file seems like overkill to me. The Miami Herald in this case is saying, yo, we'd sure like to know what's happening. News organizations are routinely permitted to intervene in criminal proceedings to seek public access to proceedings and documents. Thank you, media. Now, normally I will sit here and lambaste the media and give them kind of a hard time. But in this case, the media and all of their in-house counsel are doing the heavy lifting, because this is not the last media outlet that said, hold up. Hey, we have a First Amendment right to see what the fuck is going on. Could you please let us do that? The Miami Herald has a direct interest in collecting information about a matter of public interest in order to serve its function as a purveyor of news. Maxwell's motion for new trial and exhibits should be unsealed. So the Miami Herald makes a motion to unseal everything and go fairly thoroughly through their right as the media. Then ABC is like, you know what? You know what? The Miami Herald is correct. ABC would like to join in the request of the Miami Herald and the New York Times. Us too, us too. Yes, the New York Times also filed a motion. When did the New York Times file theirs? See, these are all from the same day. I think the New York Times filed theirs before ABC. Somebody filed in the morning, somebody filed in the afternoon. But the New York Times also filed and was like, hey, I don't love the letterhead for the New York Times. I got to be honest. Like the margin's just too big, and then this is all too I have no idea what is happening. Okay, technology. Sure. Today's the day, technology. Today's the day. The New York Times would also like the exhibits and the questionnaires, right of access, all the things, doing the heavy lifting. Thank you, New York Times. They basically said the same thing that the others said. So the media is now like, hey, we would like to lend our voices to actually get some information. Then the court was like, I've got some things to say. So the same day, January 26th, as all of this is going down, the court is like, okay, here. This court is in receipt of defendant's motion for new trial on the exhibits. The court's also received requests from media organizations to unseal the motion. The court is aware that there is a substantial public interest. Thank you. There is. We're the public. We are interested. There's over 3,000 of us in here. Have you all liked and subscribed? If you subscribe, you can chat. It is set to chat. It's set to subscribers mode. So do the likey, subscribey, YouTubey things. That'd be great. Thank you. Okay. We're going to keep going. The court is aware there's a substantial public interest and will ensure that the First Amendment right to public access is fully safeguarded. At the same time, the court must act deliberately and hear from the parties in considering these sealing issues in order to ensure the integrity of any potential inquiry process going forward, should one be ordered. So it's not it's literally the answer I give my kid. Yes, but not right now. Yes, but later. Because if there is an inquiry process into Juror 50, I understand the need for some things to be redacted, because they're saying that integrity is also in the public interest as well as the defendant's and the government's interest, which come first. To the extent the defendant requests the arguments in favor of sealing should themselves be sealed, that request is denied. So the defense was arguing, I know you guys are like, what is happening? The defense was arguing that their arguments to seal should be sealed. So you can't even see what arguments I'm making to seal it. That should also be sealed. And the court's like, no, you have to make the arguments regarding sealing. We're just talking about whether this should be sealed. We're just arguing. We're not even at the first part yet. What should be sealed? What shouldn't be sealed when we're making these motions before we get to an inquiry, before we get to a motion for new trial, because we're not even there yet. Should the arguments over sealing be sealed? And the court said no. The arguments over sealing should not be sealed. So the arguments over sealing are now public, and those were filed at the beginning of February. And we have now waited long enough to cover this that we will be able to get through some of those. So, well, kind of get through some of those. So then the Daily Mail makes another request. The Daily Mail makes a request to unseal. ABC makes a motion for Juror 50's motion, the one that is being temporarily held under seal. So ABC's like, right, but also the other one. Like, we want the other motion too. I do too. Then there are motions from Maxwell and motions from the government about what should and should not be sealed. So then the court makes a court order. I know this should have been its own episode. We can do a deeper dive into this if you want to. I think it's too thick to really do a deeper dive into because there's so much here. So this is from February 11th. And I'm using the court summaries because instead of going back and forth, I think it's easier to just go through the court summary of what they argued and then what they ruled, because there is so much stuff, because they're still arguing about how to bring the motions. We're not even at the motions yet. We're arguing over what should be sealed and what shouldn't be sealed. The court is in receipt of the parties' letters addressing the defendant's request to temporarily seal motion for new trial and accompanying exhibits. The government's response in opposition. Several media organizations have also filed letters seeking unsealing. Thank you, media. The court is also in receipt of Juror 50's motion to intervene, but the government and defense oppose intervention. The defendant seeks to strike in the alternative seal Juror 50's motion. I want to know what is in Juror 50's motion. For the reasons outlined more fully below, the court rules as follows. Yay, there's a ruling. First, the defendant's motion to temporarily seal in the entirety all the documents related to the motion for new trial is denied. Yay! Any sealing of judicial documents must be narrowly tailored. Wells Fargo, I'm looking at you. Narrowly tailored. You can redact sentences, paragraphs, names, information, monetary amounts. What you can't do is seal the whole motherfucking thing. Narrowly tailored to serve competing interests. In this case, important interests include preserving the integrity of any inquiry process going forward, as well as protecting juror anonymity and privacy. Look, Juror 50 put their whole face on these interviews. That was a choice. Protecting these interests, however, can plainly be accomplished through tailored redactions. Yay! Following the court's resolution of defendant's motion or a hearing if one is ordered, all redactions will be promptly unsealed except those necessary to protect any continuing interest. Good. Second, the court denies Juror 50's motion to intervene as it is unnecessary and unsupported by any authority or precedent. Juror 50's motion to intervene, however, will be docketed because the court denies the defendant's request to seal the motion. Even though the motion to intervene is denied, it is a judicial document to which the presumption in favor of public access applies, and no interests are served by maintaining it under seal. I haven't seen that unsealed yet, by the way. I've been looking. The court first addressed the defendant's request that this court seal all documents related to the motion for new trial, either until the motion is resolved or until after a hearing is conducted, should one be ordered. The court considers the request to seal pursuant to the three-part test, and then they go through the Lagos Pyramid Company test to determine whether sealing is appropriate. Again, narrowly tailored, and this is the balancing test of the competing interests. Both parties agree that the motion papers are judicial documents subject to a strong presumption of access under both the First Amendment and common law. That's how we do it. It's going to be like that today. The rain has lifted a little. I'm no longer as distracted. And now we can just sing, "This is how we do it. This is how we do it." Look at the First Amendment coming in clutch. However, the defendant argues that sealing pending a hearing or resolution is necessary to ensure the integrity of any fact-gathering process. The juror gave an interview to the Daily Mail. What more integrity would you what what integrity? What? You gave the okay. No, I know what they mean, but it just against the backdrop and the context, it seems ridiculous. But I understand that for the defense, this is a very big deal. And I am not poking fun at the defense. They are very well doing their job. And it is very probable that a new trial could be ordered here to the point that the government offered to resolve the matter and drop the two perjury claims to drop this motion, to which the defense was like, no. So I understand what the defense is doing, but also the backdrop is that these interviews have been given very publicly and on video. And I covered those on the playlist in another motion. The court agrees that the integrity of any inquiry is a higher value and must be weighed in determining public access to the documents. The court has previously articulated it must ensure the integrity of any potential inquiry process going forward. So the court wants these to be narrowly restricted. So what do the attorneys do next? We've already gone to the court's ruling. We're not doing a deep dive into why the court ruled what they ruled. So then the attorneys started arguing over what should be redacted. And that's where we find ourselves today. What should and shouldn't be redacted is where we are because we're still going through proposed redactions. Here's the court's latest order. And then we'll go back to the defense motion. This is where we're at. This is from February 18th, 2022. The court is in receipt of the parties' proposed redactions. So now there's motions over redactions. To the defendant's motion for a new trial, the government's response and opposition and defendant's reply. The parties did not propose any redaction to Juror 50's motion, nor the party letters dated January 13th, 2022. The defendant submitted a letter justifying her proposed redactions. The government submitted their opposition. The court determines that the following proposed redactions are not consistent with the court's prior order, because they redact information that is widely reported in the press and or redacted legal arguments. The legal arguments shouldn't be redacted. So defense brief, and then these are the lines that they're proposing be redacted. Government response, these are the lines they're proposing be redacted. Defense reply, these are the lines they're proposing being redacted. They're arguing over the redactions, but at least we get to see the whole sausage get made. There are clear inconsistencies between the defendant's intended redactions as stated in her accompanying letter and her proposed redactions. Compare docket number 602 with proposed redactions to the Maxwell brief at 48 and 49, and between some of the proposed redactions themselves. So the court is not happy with the proposed redactions. The defendant also proposes redaction to Juror 50's exact responses to the questions in the jury questionnaire because it is being kept temporarily under seal. The court notifies the parties that Juror 50's completed questionnaire will be docketed in advance in accordance with the forthcoming order. Ooh, and then we'll get to see it. The defendant must accordingly eliminate proposed redactions premised on the sealing of Juror 50's questionnaire. The parties are ordered to resubmit via email revised redactions to the parties' briefings by February 22nd, 2022. And the proposed redactions shall be consistent with this order. Stop fighting and let's get these on the docket. So hopefully by Friday, we will be able to go through the actual motion for new trial, because there have been, the end of trial started with docket number 567. We are now at docket number 606. So we're going to get to see the questionnaire. We are going to get to see Juror 50's motion to intervene, and we are going to get to see most of the motion for new trial and the government's response, and they're all going to come at once. So I will either do that on Friday or as a podcast episode, but it took an hour to explain how we got here because it is so much legal that is happening. But I think it's important to understand how hard this is being fought behind the scenes. The things we have not gotten to yet is an amicus brief from the National Association of Defense Lawyers saying, hey, a new trial should be granted, and the previously redacted version of the defense motion for new trial, but that's going to be re-redacted. So because that's going to be re-redacted, we'll go through the newer version instead of the older version. Also, when I was still working as a DA, half of the redactions I did with like grease pencil, if I had had an iPad that I could have redacted shit on, my life would have been so much easier. My life would have been so much easier. So this is so much litigation over what can be seen by the public, which is why continuing to look at these cases matters so much, because we need to know. We have an open court system, and an open court system means we get to see what the fuck is happening. And I think that is a very important part of our court system. It was part of the founding of our court system, because the defendant's right to confrontation, and we'll get into that as we get into the Duggar motions, is something that our founders said, we don't like the way this is being done. Well, in England, really. We want the person accused to see their accuser, to know who's accusing them, and to know what's being said. And that is part of why public trials matter and access to courts matter, and why I do what I do, so we can talk about it. So that was a long way to get to. We're almost there, folks. Oh, we're halfway there. Oh, living. We're halfway there. We're going to get the motions. We're going to get to see shit. I'm very, very excited. We're just not there yet. And when we get to the next video, I'm going to have to be like, go back to this video. Are we ready to talk about Duggar? I feel like I want to say we don't talk about Bruno, but I don't feel like Duggar deserves that respect. Sorry. I'm trying not to be snarky. Here's the thing. As we get into this, there are, let me swoop, and then I will tell you the things I want to tell you. Let's just heavy sigh. Let's swoop. Okay. I previewed these documents to get into the Josh Duggar case. We are getting into the Duggar motion for new trial. I don't think this is going to go as well as the Maxwell. Based on what I've seen in Maxwell, I think there are big problems. I want to see what exactly Juror 50 said, but I think there are big problems. I don't think that means she won't be reconvicted. I just think there are big problems. I don't see big problems in the Duggar case. But in this, there are more details that are more graphic. And just know that some of those things will be on screen. I will let you know they come up in the government's motion, because there is a more detailed exploration of whether or not Duggar knew that the files on the computer were, I will switch between CP and CSAM images, illicit images of children doing adult activities. So I will just note that. I will also note that it is hard with Duggar to parse out the emotions from the legal motions, because these types of crimes trigger very deep protective instincts of what the fuck, this is not okay. I totally get that. But like we always do in the chat, we are going to evaluate not the person, but the legal motions. The defense attorneys here have done a good job. The defense attorneys are doing a good job. The facts that they're up against are not good for Duggar. I don't think this motion will be granted, but we are going to talk about what this motion gets into and why. And we are not, and I am not going to fact check other creators. I get asked a lot. I just don't. I am not someone else's fact checker. We're just going to talk about the facts over here. I don't know the rest of the family. I am not going to explore the rest of the Duggar family. I can only imagine that this is tremendously difficult for those that had no idea what was going on, if there are any. I don't have a lot of empathy for his parents. They knew, based on court documents, what I've read, they know some of the things. So let us talk about this. Rainy Cakes asked an excellent question, and I'm going to answer, and then I'll get to Q&A at the end of this motion. Is it still alleged if they're already convicted? No, it's not. It's not still alleged. These aren't allegations. But, well, The charges aren't allegations. He's been convicted of a jury. Just like saying Tasha K committed defamation, a jury found that. That's a fact. A jury found that she committed defamation. So not saying this is someone convicted of receiving and possessing these things. And with that, we're going to get into the new trial motions. The new trial motions give a very good background. So we're just going to go for the summary of the motion. It looks like my highlighted motion has finally showed up in my drive. Thank you, technology, for getting me there today. I appreciate it. These are long motions. So I hope you have a snack and some water. Thank you, mods. We're going to go through these motions as best we can, and then we're going to do questions. I'm hoping we can do these motions in 40 minutes or so. That's my goal. We're not going to do a full deep dive into all of the law of these, but I will point out the case law that is directly on point and matters. The factual allegations are more important for us. So thank you, law nerds, for being incredible. I love having these conversations with you. Okay, deep breath. I hate some of the shit in this motion. Not this one, the next one. Today might have been a day for spiked coffee. All right, let's get into it. Let's talk about shit we hate. Woo! Relevant background on April 28th, 2021. Can we talk about how fast this moved? This is a win on the federal government. And I don't say that often. You know how I feel about huge government. But this is a win for the feds. April 28th, 2021 is when they indicted him. And this is the thing about the feds that Jen Shaw needs to keep in remembering. Their investigation is done by the time you're indicted. There's not much more that they need. So by the time you're indicted, they're ready to go. So the defense is always playing catch up when it comes to federal indictments. This is not true elsewhere. This is true especially in these types of cases. The investigation is done. They went to a grand jury. They presented all their facts. A grand jury went, yeah, seems like that guy did it. And then they're moving forward. First of all, Ivan, don't come troll the chat. The mods will just bounce you. She is convicted of doing a whole lot of awful shit wrong. So I disagree. The jury disagrees. She is a convicted trafficker. But I also take that as a trolling comment, trying to rile up our chat, and our law nerd chat doesn't fall for it because they know it's trolling because, convicted by a jury. So, documents. No. What was I talking about? I got distracted. Apologies. The government's case is investigated by the time they go to grand jury and present it, which is why we're going to see a sentencing on April 5th. The sentencing on April 5th is going to be like less than a year from indictment. And that is something that is fast. During a pandemic, this moved quickly, very, very quickly. So April 28th, 2021, the federal grand jury returned a 2-count indictment, 1-count receipt of the images, possession of the images as the 2nd count. At the close of the government's case in chief, Duggar moved the court to enter a judgment of acquittal. That happens at the end of the prosecution's case. In every case, it was denied. It's generally denied. The prosecution has to prove their case. And even if the court's like questioning it, they'll let the defense put on their defense and then rule that. So the court denied the motion after the defense's case in chief. Duggar moved to enter a judgment of acquittal, and the court denied the motion. That is standard operating procedure in the world of criminal law. For those of you that are new here, you can go ahead and put a 1 in the chat if you're not familiar with me. I am a former prosecutor. I worked with the AUSA's office in law school and then was a deputy district attorney as a state level prosecutor for over 10 years. So when we get to criminal law, it's like juries are my thing. I did a lot of jury trials, and I think that being a trial attorney brings a different perspective on these things than not being attorney or not being a trial attorney. So I love to share just kind of the behind the scenes of how this all works. Federal court is much more formal. Most of this happens by spoken motions in state court. Thank God for me. I loved oral argument was my favorite. This court should enter a judgment of acquittal on both counts. So the defense is asking for an acquittal or, in the alternative, a new trial, or in the alternative, count 2 being dismissed, which is going to happen. They get into Rule 29. If the jury has returned a guilty verdict, the court may set aside the verdict and enter an acquittal. This is a judgment notwithstanding a verdict. We talked about this on, was it Friday that we talked about Sarah Palin's case? That's not a criminal case. That is a civil case, but this can happen when a judge says there's no way in flying fuck that a jury can convict someone. There's just, you have not proved the facts. Just as a matter of law, this cannot stand. You did not prove it. That's not this case, I think. They go to the first step of evaluating a Rule 28 motion to determine what crime was charged, and then they go through the elements so helpfully. The reason I'm going through the elements, and we've gone through the jury instructions, is just to remind everyone what we're talking about, and I like the way that the defense broke out their motion. It is a good motion. These defense attorneys have done a good job. I don't agree with the positions they have to take, but they've done a good job taking positions that are difficult because the facts are the facts. So this is count 1. These are the elements of count 1. This is what had to be proven to the jury. Between May 19 and May 16, 2019, Duggar knowingly received visual depictions of CP. Duggar knew, this is going to be a lot of what they argue, Duggar knew that the visual depictions were of a minor engaging in explicit conduct. That's where the whole yuck comes in the next motion. Third, that the visual depictions had been, transmitted through interstate commerce. The wires count, the internet counts. First, this is count 2. Count 2 being a lesser included crime, but count 2 is knowingly possessed the computers on the file and that they were visual depictions of CP. That Duggar knew that the visual depictions were of a minor engaging in explicit conduct, and that Duggar knew that the items contained CP, which involved a prepubescent minor child under the age of 12. And fourth, that they were transmitted, across the internet. Those are not the hard elements. The element they're really going after here is Duggar knew. What did the government prove that Duggar knew? The evidence elicited at trial does not support a conviction on either count, even in the light most favorable to the government, which is the standard here. And we talk about the standards on motions to dismiss. It is everything viewed in the light most favorable to the non-moving party, here the government. So everything viewed in the light most favorable to the government. Specifically, I love an arguendo argument. They're very powerful. Law students, lawyers, take note. Judges like arguendo arguments. You've got to give them both sides of the argument. So even accepting arguendo for the purpose of argument only, and for only the purposes of this motion, the allegation that Duggar received and possessed the images, the government failed to adduce any evidence that Duggar, quote, knew that the visual depictions were of a minor engaging in sexually explicit conduct. And here is the door being flung the fuck open with a wrecking ball for the government to come in and be like, would you like us to share exactly what some of these files were? Good. We haven't gotten into this in a public forum. We've gotten into this at trial, but let us get into this a little bit more. Indeed, the evidence at trial established that certain files allegedly found on the HP desktop computer were never viewed by any user of the computer, and that all files at issue had been deleted shortly after being downloaded. One could argue that it's because one viewed them and knew they were fucking illegal and then download them. One could say. One could posit. So they're saying, thus, even in the light most favorable to the government, the jury had no evidence that Duggar personally viewed any specific portion of any files allegedly found on the computer. Notice that we didn't talk about viewing. He had to receive them and possess them and know what they were. They don't have to prove that he watched them. They have to prove that he possessed them and received them. The receiving is the interceding out of the air stuff. So that's what their argument is. No evidence of mens rea. They go on to say, in the alternative, So if you don't acquit, which is not going to happen, if you don't acquit, then we get a new trial. And the new trial's on different grounds. And if you don't acquit, we get a new trial based on, and these are their 4 arguments. 1, the government violated Brady and Giglio obligations by failing to timely disclose exculpatory evidence. Brady obligations are real. We'll talk about that at this point, or at the point of the motion when we get to it. The Duggar was effectively precluded from calling a necessary witness, Caleb Williams. I disagree very strongly with that. 3, the government violated the Jenks Act, FRCP 16, FRE 705 by failing to turn over exhibits created by the government expert witness. I think even if that did happen, you're not getting a new trial for it, but we'll go through the facts on both sides. I should say Duggar's side has not filed a reply to the government yet. We'll go over it when it's filed. They got an extension and it was time to get to this. Fortall, the expert, was permitted to testify as about geolocation, despite the fact that this constitutes expert testimony, and he was unqualified to render. We'll get into his role in the government's response. We'll get into his role in the government's response. They have to make the arguments, y'all. I don't have to agree. They have to make the arguments, and they do a good job making the arguments. The government's Brady and Giglio violations require a new trial because the government failed to disclose material exculpatory evidence related to Caleb Williams, and that entitles Duggar to a new trial. I disagree. In this case, they say the government was aware in advance of trial that Duggar intended to elicit evidence inter alia that Williams was an individual who had had access to the car lot and the HP desktop computer during certain relevant time periods, and that law enforcement had failed to meaningfully investigate the possibility that anyone other than Duggar could have committed the crimes. We knew this was their argument from their pretrial motions. All those motions in limine, we knew that it was someone else, someone else, someone else. That's the only defense that they had. The stuff was on the computer, my opinion. The stuff was on the computer. You can't attack that the stuff is on the computer. The only way to attack is somebody else put the shit on the computer, not him. Or there's enough doubt that it was him that you can't convict. Because again, the defense just has to have jurors say, yeah, there's a reasonable doubt who put this on the computer. They say, indeed, following Duggar's pretrial filing, the government interviewed Williams for the first time and provided the defense with a report of an interview on November 16th, 2021. However, this interview was not the last of the government's communications. They say Williams contacted, not the government contacted. Williams contacted the government on multiple occasions in advance of trial. On November 24th, 2021, Williams spoke with AUSA Dustin Roberts and HSI Special Agent Faulkner, which is appropriate because the attorney can't be a witness in their own case, so you've got to have somebody else with you on an interview. So they spoke to both of them by telephone and made certain statements relevant to the case, according to the defense. Furthermore, the same day, Williams apparently sent an unsolicited email to the Department of Justice's trial attorney, William Clayman, in which he wrote, I was completely mistaken about not being at the Wholesale Motors car lot during the time I was in Arkansas between May 8th and May 11th. Remember, the alleged time frame here is May 13th. And we'll get into this in the government's motion too, but May 14th to May 16th. May 13th is relevant because May 13th is when they believe the partition was downloaded. So the whole breakdown of the case is on the playlist on the channel, but there was a partition on the computer and all of the stuff was behind a partition. The partition was downloaded before all of this was downloaded, very quick in time. So this individual is saying, I might have been at the car lot between May 8th and May 11th. This is several days before the partition was downloaded and the images were downloaded. I do not know if I was on the lot computer or even if I ended up going there. It looks like during my time there, I did odd work for the guys and maybe even Josh Duggar. In the messages between Josh Duggar and I while I was in Arkansas, as attached in one of the screenshots I'm providing, I tell Josh I was planning to come to the lot a couple of days. I apologize for the mistake. I had no intention of misleading y'all. In this email, Williams admitted that he misled government investigators during his previous interview. I don't read it that way, but again, this is the defense and this is their job. This is the defense viewing something in the light most favorable to them. I think what he said is, I was mistaken about what happened several years ago during this period of time, and now I've clarified that I was mistaken. They go on saying, despite having received the email on November 24th, 2021, the government did not disclose this information until the evening of Saturday, November 27th, 2021, just 3 days before trial. I will say, in defense of lawyers everywhere, I didn't check my email much before trial either. I expected everything to go through my detective. I did not. If I was on the eve of trial, I often did not check my email because everything needs to go through my detective and they need to tell me what's needed. I don't have time. But that's just a neither here nor there. They say Williams appeared eager to voluntarily speak to government counsel and investigators. He was far less willing to speak with the defense. I just wonder if there's other context to why he didn't want to speak to the defense. I'm just curious. The defense subpoenaed Williams to testify at trial. Trial commenced November 30th. On Sunday, December 5th at 6:38 p.m., the evening before the government rested its case, the government notified counsel that Williams had sent another email on November 30th, 2021, the first day of trial. Again, I wouldn't be checking my emails when I was in trial either. Government counsel provided defense a copy of the emails, the email that Williams had sent during the first day of trial, which they should do. Even though I don't think it's exculpatory. The defense immediately inquired as to why the government had waited 5 days to disclose the email and waited until a Sunday evening, but received no response. In the November 30th, 2021 email that was not disclosed till defense until 5 days after trial, "We've heard you. We've heard you." Williams wrote, "I've also found a few more passwords if you all want them. At some point, several of the Duggar guys asked me to run the back ends of some of their social media to help them sell cars. Jed, Josiah, and Joseph, I do believe. I still have access to Jed's fake account and Josiah's account." Here's all I'm saying. None of that says Josh. None of that says he has access to Josh. None of that says Josh. They say this is critical. At trial, the issues of passwords utilized by the perpetrator of the offenses charged was discussed by nearly every witness, and this was a cornerstone of the prosecution's case. One of the principal strategies of the defense was to attack the government's incomplete investigation of the case and that law enforcement's failure to meaningfully investigate the possibility that anyone other than Duggar was responsible for the crimes. They go on to say that the government hid the ball from the defense. William told prosecutors in the email that he found a few more passwords. And I keep saying, but those aren't Josh's passwords. So again, it has to be relevant and exculpatory. And I don't think it's exculpatory because it's not related to Josh. It's related to his brothers. They're saying that this deprived defense of the ability to impeach witnesses with evidence, yet another person had access to the passwords. Again, they're saying, look, the defense is making the argument, look, we could have said, but other people had access to Josh's passwords. But the email doesn't say that. It doesn't say he had access to Josh's passwords. It said he had access to other people's passwords. The defense addressed the government's late disclosure of this exculpatory evidence. I'm not so sure on that conclusion. On the record and in chambers the morning after it was disclosed, that's the right thing to do. Go to the judge and be like, what the fuck? Your Honor, they didn't give us the email. Rule number one. Defense counsel noted. So this is from the transcript of their argument. Number one, if Williams provided passwords he had access to the government, that's a very big deal in light of the government's theory. Second, the government had in their possession evidence that a third party clearly had access to Duggar family social media passwords. But that's not Josh. Which clearly, at least circumstantially, gives rise to the argument that others had access to the Intel 1988 password and perhaps others. I think that's a stretch. The court then asked the government why they had waited 5 days to turn over the email. Government counsel stated, Your Honor, one, these were unsolicited emails. We didn't ask Mr. Williams to send the emails. We got them in the middle of trial. We've been in trial all week. We honestly did not review it until Sunday, which after being in trial, I believe them. The government's obligated to turn over exculpatory evidence in their possession. I don't think we're going to have to split hairs over whether or not this email was in their possession. If they haven't seen it, they're obligated to turn it over even if they haven't seen it. That's part of the Brady obligation. I think the argument is that this email is not potentially exculpatory, but I've made exposition now, so I will breeze over it as we get into the government's argument. And they say that's what we meant to discuss. This is what we're going to do for the rest of our case. What we're going to do, okay, they are trying to call Caleb Williams. Let's look at the email. Okay. Cutting to the chase, the court asked, back on the Brady issue, Mr. Clayman, this email that you disclosed last night that came in several days ago, my understanding is that you just realized that you had this email and viewed its contents last night. In response, Clayman explained, we reviewed its contents together last night, yes. And the defense says this seems to be non-responsive. In that, I agree with them. It seems to be, it doesn't say, the court said, it's my understanding that you just realized you had it. But without more context, I don't know if there was anything in between that. So the government says we reviewed its contents together last night and then turned it over to the defense. I don't think either way this is exculpatory because it's not talking about Josh's passwords. They go on to say that under these cases, evidence is material if there's a reasonable probability that had it been disclosed, the result of the proceeding would have been different. I don't think this email is going to meet that test. But that's one of their arguments, that the government withheld this evidence. They argue, or the defense argues in this case, Duggar was deprived of a materially exculpatory evidence until the evening before the government rested its case, because there were more passwords, implying that he had previously provided passwords to the government, which to this day has not been disclosed. So who knows if he disclosed that he had passwords or not, or just said, I have passwords, here's more passwords, because they're not relevant to Josh, and they're not going to disclose the passwords of other family members that aren't relevant to this case, is how I see it. They're saying that that substantially affected them. They then go on to say that Duggar was precluded from calling this witness, Caleb Williams, to testify. The defense offered a proffer of Williams' testimony. The defense proffered to the court that Williams previously worked at Wholesale Motors, would authenticate a March 27th car sales contract listing him as a salesperson. That's not May. Would demonstrate familiarity with the HP computer and certain software on the computer. Has involvement with eBay sales and utilized the HP to print shipping labels. The HP's partition, though, there's two sides of it. There's a password protected side where all this happened. And then there's another side that has a not spyware, that's the wrong word, a Covenant Eyes program that can track a monitoring software, if you will. So there's a partition there, but maybe this witness could have testified whether the partition was in existence when they used the computer previously, if they saw that you could log into the partitioned side. I don't know. And side's hard because it's like within a thing. Sent a message to Duggar May 7th saying should be able to help you in a couple days this week. Happy face. Spent the night at Champion Motor Cars a mile away on May 9th. Again, that's not the relevant time period. Took a photo of Duggar using a MacBook laptop in the Wholesale Motor Cars office. Okay, so he also used a MacBook. While denying he was on the car lot to the government, this was subject to impeachment as based solely on his testimony and documents he provided. I will say that the documents he provided that he was elsewhere on on the dates in question, May 14th, 16th, the things included like a Genius Bar ticket from him having his phone worked on in another state, photos of him with his family in another state. So he provided evidence that he was not in Arkansas during the relevant time period, which might make his testimony not relevant because he wasn't there. The court asked if the overriding purpose for which you're seeking to call Williams would be able to make the argument that he was an alternative perpetrator for the offense between May 14th and 16th. The defense said yes, but not exclusively, because he also has circumstantial evidence that shows, even just for the fact that he sold a car as a salesperson, that there were other salespeople on the lot. The court ruled, quote, So to the extent that the overreaching relevance and purpose of calling this witness is to establish a so-called alternative perpetrator evidence, based on this proffer, the court will not allow Caleb Williams to be associated with an alternative perpetrator evidence or argument. After identifying certain case the court viewed on the and supported its decision, the court ruled. Against that backdrop, the information you have, including the fact that he wasn't on the lot during the relevant time period and had evidence to that, you may ask Mr. Williams, and you may establish background of who he is and what his connection is. You may discuss the dates of his employment. You may ask him whether or not he has knowledge of recollection of being present on the car lot about on or around May 13th through May 16th. Defense conduct is May 14th through 16th, but there's evidence that the Linux partition was installed on the 13th. And you may inquire if he ever remoted into the office machine, and if so, what time periods. If he establishes that he was present or had remoted in, then we can take this one step further. So you have to establish a foundation. A foundation. It goes, the court went on to say, however, assuming the government seems to be indicating that he was not present on the lot, and I don't know whether they know whether he's ever remoted in or not, but assuming he testifies he's never remoted in, that's as far as you're going to get, and the court would find that instance under 403 or 609. And the court would find that instance under 403 that the 609 conviction is a conviction of a sex offense that you have discussed should not be allowed. Again, it wouldn't be relevant at that point. The primary purpose or objective of calling the witness will have failed, meaning if he's not a alternative perpetrator, then you can't get into the fact that he is a convicted sex offender because he wasn't there. And the court's not going to allow any speculative testimony, which is legally proper. They say the ruling by the court on Duggar's right to call Williams to testify thus was that Duggar was not permitted to meaningfully inquire if Williams simply testified that he was not on the car lot at any point. But there's like documentary evidence that he wasn't at the, there's documentary evidence that he was in another state. So they're not going to allow you to wildly speculate, defense, but you can call him and ask the questions. They chose not to. They were not precluded. This argument pissed me off. They are doing their job. They are doing their job well, but it is the stretchiest of reaches to say that the court precluded Williams from testifying. No, they were not permitted to meaningfully inquire if Williams testified that he was not at the car lot at any point, and if he testified that he had never remoted into the computer. By requiring Duggar and by extension the jury to simply take at face value Williams' assertions that he was not the one who committed these crimes constitutes an unambiguous violation of Duggar's Fifth and Sixth Amendment rights. You could have called him. You could have called him to testify. And then he could have been like, no, I was at the Genius Bar. Here's my receipt for fixing my fucking iPhone. And here's pictures of me with my mom in another state for Mother's Day. But I digress. Then they get into the due process clause and the confrontation clause that Duggar was precluded from confronting this person against him because his defense attorneys chose not to call him because they were going to have to establish like a foundation for this witness. This is a stretch. They then get into the confrontation clause. They could have called the witness. They say that the framers, look, if you were a defense attorney and you were arguing about the framing of the Constitution, you were losing on the facts. There was a trial I did where the defense attorney went on for most of his closing, because the case was so bad for him, went on for most of his closing about the right to a public trial, including pushing open the doors at the back of the courtroom very dramatically and yelling, "You have a right to a public trial. Would anyone like to come see?" And I was sitting at counsel table trying not to laugh because the theatrics were commendable, but when you are arguing about the Constitution, the facts are not on your side. They're just not. They're just not on your side. So the framers of the Constitution felt it necessary specifically to provide that defendants in criminal cases should be provided by the means of obtaining witnesses so that their own evidence as well as the prosecution's might be evaluated by a jury. Yes, you can call witnesses and you weren't precluded from calling a witness. You chose not to. This ruling by the court that Duggar would not be permitted to inquire further or to impeach Williams' credibility if Williams simply denied being present. What evidence do you have that he was present? What evidence do you have that he was present? What evidence? What evidence to impeach him with? You can't just impeach him with a past offense. They're saying the court's ruling that they needed like foundation was an arbitrary ruling that violated Duggar's rights. No appellate court is ever going to be with them on that. They're just not going to win that argument. The court's ruling was ostensibly premised on an apparent misreading of Holmes versus South Carolina. We're not going to get into them throwing shade at the court and trying to say that there was a different way to interpret this. The court just said they have to provide foundation and they chose not to do it, and that's their choice. They then get on to say, in preventing Duggar from impeaching Williams, including with his prior sex offense. Impeach him with what else, though? There's nothing else to impeach him with. You don't have any evidence he was at the car lot. It's not like you have another witness that was like, yeah, I was there that day and bro was there too. There's no other evidence that he was there other than asking him, and contrary evidence that he wasn't there. Okay. But they're really just milking. We're only on page 17 of this motion. Oh gosh, we're almost 2 hours in. Okay. I'm gonna stop ranting so much in the middle. We're just gonna get through it, and then we're gonna go to the government's motion. If Williams simply denied having been in a position to commit crimes charged, this court did what Crosby and Wigmore cautioned against. It predetermined a critical factual dispute and prevented Duggar from arguing the existence of reasonable doubt to the jury. I don't agree. And I don't think the court's going to agree. And I don't think an appellate court, if this goes up on appeal when it's denied, I don't think an appellate court's going to agree. At trial, the government recalled its expert witness for James Fortrell during its rebuttal case after the defense had rested. On direct examination, the government sought to introduce certain print screens from the virtual machine created in an attempt to mimic the HP computer. Well, because they had a full download, so they could. The defense could too. By the way, the defense was provided, from everything I've read, the defense would have been provided with all of the downloads. If they wanted to create a virtual machine, they could have. When the government sought to introduce these exhibits, defense counsel requested a bench conference. At the bench conference, defense counsel explained that the exhibits the government was attempting to introduce had not been provided in advance of the testimony during the government's case in chief. That the two print screens accepted in, but they allowed the two print screens into evidence, showing that it was possible to create the username Dell_1 on the Linux partition of the HP computer, and testified that Exhibit 87 supposedly showed, among other things, that uTorrent was available for download from the Linux Snap store. However, during cross-examination, Fortrell admitted that he had not created these printout scenes after his testimony in the government's case in chief, but it expressly, as the government expressly represented to the court, but that he had created the screens before trial. The court held an in-chamber conference to address this. I don't think this is a huge issue, but I understand why they'd be frustrated about it. But I think these are demonstrative exhibits. So, but I understand their frustration on this one. They're saying that the expert witness created a demonstrative exhibit before they testified. The defense should have that before the testimony of the expert so they can cross-examine the expert about it. The court, or the government, said to the court he created these after he testified, so we couldn't have turned them over any sooner. But they're saying that was contradicted in his testimony. I don't remember exactly what the government said about this, so we'll go look at what the government says. The government said it was unaware that the screenshots occurred prior to his testimony. We all saw him putting the exhibit together, and that's what we represented to the court. So, okay. The defense explained why they believed it was important. The court ruled that the exhibits were not evidence, but they were demonstrative exhibits, meaning they were showing you what could be done. And the court said, I don't understand why slides used for demonstrative purposes that are not evidence in this case would violate Jenks, especially in the context of rebuttal evidence. We'll see what the court says. I need more context on this, and then we'll go to the government's response on it for more context. Of all of the issues, I can understand why the defense would be fluffed about this. Like, this might be a lot of frustration about nothing, but also if this was created before the testimony, they had a right to have it. If it was created after the testimony and it's demonstrative, it might be a no harm, no foul, even though it's frustrating because it probably wouldn't have changed anything. Following a resource, the court held an in-chambers conference to address the issue. The government responded that it was unaware the screenshots occurred prior to the testimony last week. We went through that. I lost my place because I had scrolled. At trial during the government's case in chief, the expert testified at length about many subjects and was cross-examined concerning whether it was possible to create the username Dell1 on the Linux partition of the HP computer and whether the program uTorrent was available for download on the Snap store. Additionally, the defense expert Michelle Bush testified extensively that the defense introduced exhibits concerning these same issues. As such, there can be no meaningful dispute that the government's exhibits constituted documents and photographs material to preparing the defense. We'll see. I don't think a new trial is the appropriate remedy. I don't think it matters that much, but they're allowed to make that argument. And they kind of have to make that argument. They say it was inadequate notice to provide a fair trial. The court's saying it's rebuttal. It is. So let's see. Again, as already discussed, they go on about BitTorrent and not having that in time. Next is impermissible expert testimony on geolocation. The court found that the government's expert was an expert to talk about geolocation, EXIF data, and GPS coordinates. The government offered numerous exhibits about that. They're saying that the expert was not enough of an expert for it. They go through the federal rule of evidence under 702 about whether the expert's an expert. They said Fortrell has no knowledge about how geolocation, EXIF, and GPS coordinates work, at least so far as one can tell from having heard his testimony and reviewing the government's disclosures. And we'll get to that on the government. So they're saying he cannot be an expert, even though the court qualified him as an expert and let him testify as an expert. So he's granted a new trial on this as well. This is a very short argument, probably because there's not much else to say. We'll get into who that person is and why. And then they're asking for an acquittal and a Rule 29 judgment that apply to both. Count 2 must be dismissed with prejudice. Count 2 does need to be dismissed with prejudice. I agree. Look, I agree. It's a lesser included, but it will be dismissed with prejudice at sentencing. Not until after this is decided, because these have to be decided first. Because if you win your new trial motion, you're not getting a new trial. So let's go to the government's response. And I should probably timestamp it. Thank you, mods. You all send the mods some love for riding over 2 hours. Apparently that's just what we do now. Emily, can you be brief? Nope. Never. All right, let's get to what the government says in their response. Let's see, that's not my highlighted one. Where is my? There it is. All right. And again, Duggar was granted an extension of time to reply, so there will be a reply. This motion gets into the name of, remember, the defense is arguing that there's no way he would have, the government didn't prove he knew what those files contained. Some of the names of the files are detailed here. Blech. They're not okay, but they are detailed here. And we're just going to go through it because you know what? Here's the thing. This shit happens. This shit happens a lot. I don't think shying away from, hey, this is what happens in the world is helpful to anyone. So we're just going to get into it because, again, this happens. This is a very large problem. Not just the creation, but the market that creates a need for the creation of this type of content. There's a reason there's laws against it, but it's still an ever-growing and ever-present issue. Both of these cases today, really. All right. Oh, wait, there was more from the defense. Hold on. Did I get through all of where were the exhibits? There were exhibits on the defense motion that I did not get to. Hold on. I was like, oh, there were emails attached. So I just want to show what the defense attached for completeness. So the defense attached all of the emails that they were provided. I'm going to try to make this bigger. So it's a whole bunch of screenshots that were emailed from the Caleb Williams individual. This is the full context of the email. So when I said there was contrary evidence, because the defense is arguing he could have been an alternate perpetrator. We could say, look, we don't know. This guy was there. He had access to the computer. Somebody downloaded it. How do we know who's at the keyboard? This is the email that they have when they made that argument. So you can decide for yourself if this shows to you that somebody was likely at the car lot during that May 14th to 16th window, or May 13th to 16th window. You can decide for yourself. This is this is the email that came in right around Thanksgiving. This is Caleb Williams. Earlier, I spoke to Roberts and Faulkner regarding the upcoming Duggar trial. Hopefully, this is a good email to send this information. I've been able to assemble some documentation from my computer for you all to review. It's so weird to me that it doesn't just say y'all, but okay. We're being formal with y'all. If you need more, please do not hesitate to reach out. Your email address was listed in the filing from this case. I was completely mistaken about not being at the Wholesale Motors lot during the time I was in Arkansas between May 8th and May 11th. I do not know if I was on the lot computer or even if I ended up going there. It looks like during my time there, I did odd work for the guys and maybe even Josh Duggar. In the messages between Josh Duggar and I, while I was in Arkansas, as attached in one of these screenshots I'm providing, I tell Josh I was planning to come to the lot a couple of days. I apologize for the mistake. I had no intention of misleading you all. It's difficult for me to go back and remember the details of that trip without referencing things from that time. Again, I don't think he was being intentionally misleading. I don't. It then goes on. This is the part that was left out of the motion and is just attached. From what I can tell, I left Illinois with my brother on May 8th with plans to go to a doctor's appointment and visit my brother, Josh. All the Joshuas. Okay. Who is incarcerated in the Benton County Jail during that time. I mean, if he went to visit, there would be a record of that easily. I detail what looks like 2 vehicles for Jed Duggar. I may have spent time at the Duggars' home, gone to a church in Springdale, see messages with John Boyd, visited the Duggars' house, and even possibly been at the Wholesale Motor Cars and, he says possibly, Wholesale Motor Cars and Champion Motor Car lots on May 11th. Lots on the car lots, period. On May 11th, I left Arkansas. I drove to the Apple store at the Galleria Mall in St. Louis, Missouri for an appointment to repair my damaged iPhone X. Apple replaced my iPhone X and issued an email receipt acknowledging the described transaction from the Apple store in St. Louis. So May 11th, he was in Missouri. It looks like I traveled to my parents' house near Devlin, Illinois, and took the picture in their kitchen that night. The next day was Sunday, which was Mother's Day. It looks like our family got together that day. I will see if I can track any images down. From May 13th to May 16th, it looks like I was at my grandparents' home in Midland, Illinois. There are text messages from that time and screenshots attached. On May 17th, it looks like I traveled to Indiana with my family for a cousin's wedding. So again, this email lines out that he was not, in fact, in the state of Arkansas during that time. And the defense doesn't proffer anything at all to say, well, this is how we know he could have been at the car lot or was at the car lot. So there's nothing to impeach him with. So the judge's ruling just isn't wrong. It says on the other note, you may be getting records from Roger Smith and SNS near Tawnytown. He would work on some of the Duggars and Duggar cars. I left a message. And then if there's anything that might be useful, let me know. Have a good Thanksgiving. And then attaches a literal, veritable F ton of screenshots and including text messages between people, exactly what was said. I mean, it's all very forthcoming. And that's what the government had. So I don't think, and that's what the defense had. I don't think there's anything in here that the defense can argue shows he would have been at the car lot during those time, except for speculation. And there's an Apple receipt. And again, that's also a third-party record that's created with a timestamp. So I don't think it's a huge issue. Also, a lot of these text messages are between Duggar and this individual. Josh Duggar's lawyers would have had all of that information before the government did because they have Josh Duggar and his phone, and they can ask him, was anyone else on the car lot around these days? So they had access to this too. The other reason why I'm not like, look, if they wanted to try to get more of this information, they could have. It's not like they were unaware this person existed. Josh knew who this was. They have the defendant. And then this is from the Apple store. With a date from May 11th. All right, let's get to the government motion. There's pages and pages and pages of this, including more from the Apple store and stuff like that, and more text messages. But for our purposes, I wanted to point out that the email as proffered by the defense maybe is a little different when the entire context is there. You decide. All right. Government response. Defendant was charged in a 2-count indictment. On December 9th, the jury found the defendant guilty. The defendant asked the court to overturn the verdict, claiming there is no evidence he personally viewed the CP, but his bare bones argument ignores the ample proof beyond any reasonable doubt that he repeatedly downloaded and viewed this material on a password-protected partition and that the files had titles indicative of their illegality. The defendant asked the court to grant the extraordinary remedy of ordering a new trial for a variety of reasons, but those arguments fail too. He claims that the court prevented him from calling as a witness Caleb Williams, a man who could not have committed these crimes based on defendant's own evidence, but who he nonetheless sought to implicate, and criticizes the timing of the disclosure of emails from Mr. Williams. But contrary to his misleading framing, he was not prevented from calling Mr. Williams. He simply opted not to when told he would need to satisfy the federal rules of evidence, like a foundation, before improperly injecting Mr. Williams's prior sex offense into the trial. Further, the emails at issue are wholly immaterial, but they are still disclosed promptly after they were reviewed and in time for the defendant to attempt to utilize them at trial. I also agree. They were not material because they had nothing to do with Josh. He also argues that the new trial is warranted because the timing of the disclosure of the government's demonstrative rebuttal exhibits allegedly violated Rule 16 and the Jenks Act, and because the testimony about iPhone metadata from James Fortall, director of the Department of Justice's High Technology Investigative Unit, was improper expert testimony. We're just going to leave that the director of the Department of Justice's High Tech Investigative Unit might have some expertise in high-tech investigations. We'll get into that later. They say that the demonstratives merely illustrated the testimony from the government's case in chief, meaning it showed in a visual way evidence that had already been, or testimony that had already been elicited. And that's what I supposed too. It's showing, again, in a more visual representation for the jury, what was already said in the case in chief. So it is not a problem. They say to the extent that it was expert testimony, Director Fortell was qualified to provide it, and the defendant received adequate notice of it. Indeed, he had the inapposite case law readily available at trial to object to the testimony he now claims he could not have anticipated. We all anticipated it. We all knew this was coming because this was all in all of the motions in limine. You can't say you didn't know that they were going to argue that Duggar was at the car lot based on photos on his iPhone because that was all in the pre-trial motions. We talked about it all the time. We talked about it a lot. Oh, how are they going to prove he was in the lot? Oh, they've got all these GPS geotagged photos from his iPhone where he's at the car lot. And then they have text messages back and forth to his wife saying, I'm going to be late. I'm going to be this. I'm going to be that. They knew he was at the car lot because he said so and because he had pictures. Okay, Emily, breathe, take some water, and let's continue on. I agree that they had the heads up. The defense is doing their job. It is their job. They have to do their job. But also, the government then says all this shit should be denied. And they get into the procedural background. So we'll do a little bit of that. Pursuant to FRCP 16A1G, the government provided the defense with its expert notice on July 16th, 2021. The notice explained that the director may testify about his examination of the defendant's devices, and that either the director or Marshall Kennedy, a computer forensic analyst. This is why I try not to go over 2 hours, because the words get harder. A computer forensic analyst at the HSI may testify about the images containing metadata, including geolocation information from the defendant's laptop, which was documented in other discovery provided to the defense. The reason it's from the laptop is that's where they recovered his iCloud from. But the images are from the phone. He just recovered it from the laptop from the iCloud because it was backed up on iCloud. On August 20th, 2021, the defendant filed a motion to dismiss, claiming the government did not preserve potentially exculpatory evidence. We went through all those motions here. They are all in the playlist on this case. They say then that the defendant partially withdrew the motion after the government informed him that his own counsel represented one of the 3 individuals in a different case that resulted in that individual being incarcerated during the charged time frame. And the court ultimately denied the motion because he attempted to blame others for his crimes based on demonstrably false speculation. The government moved to preclude the defendant from introducing an unsubstantiated alternative perpetrator theory at trial, absent a non-speculative nexus between the crimes and the alleged perpetrator. Argument. The court can only enter a judgment of acquittal if no rational jury could have found the defendant guilty. I don't think we're even in the realm of that happening here. They say defendant is not entitled to a judgment of an acquittal. The jury's verdict should not be thrown out and a judgment of acquittal entered because there's no evidence he, quote, personally viewed the explicit images, which he claims is an essential element of the offense, which is not. The court, however, quote, has a very limited latitude to do so and must not assess witness credibility or weigh evidence. When reviewing such a motion, the court must resolve all evidentiary conflicts in the government's favor, accepting all reasonable inferences that support the verdict. They then go on to say the crux of the defendant's motion is that there was no evidence he personally viewed the CSAM at issue, which he claims is necessary to prove he knew the visual depictions were of minor children engaging in explicit conduct. Just buckle up because we're getting into it. Just getting into it. The defendant's motion not only ignores the ample evidence proving he viewed this material, but it also critically misstates the element the jury considered when determining his guilt. Here's what I will say. The defense has to do their job. They should do their job. They are doing their job. Everyone has the right to a defense. The thing is, I wonder how much the defense had a conversation about this motion with Duggar saying, look, not everyone attended the trial. The trial transcripts are redacted. All this shit isn't out there. But if we make these motions, this shit's going to get out of the horse real quick. And there's going to be a lot more information. And you know what? The government's like, hey, you're arguing that there wasn't enough evidence. Let us share with you why there's enough evidence. And this is more than has been provided in any other way. So I just wonder if Duggar appreciated that by trying to go down this road, the government was like, oh, we want to go there? Let us go there. They then go on to say the government did not need to provide evidence that he personally viewed the material to convict him of receiving and possessing the material. It only had to prove that he knew the material was of minors engaging in explicit conduct. On this point, the jury heard testimony from multiple witnesses, including defense's own expert, proving that the material was downloaded to a password protected Linux partition on his computer using two different programs, and he knew the programs existed on his computer. The files had names indicative of CSAM, and the files were, at a minimum, viewed in thumbnail format or played as videos. Interpreting this evidence in the light most favorable to the government and drawing all inferences that support the verdict, there can be no doubt, let alone a reasonable doubt, that the defendant knew that the visual depictions he received and possessed were of minors engaging in explicit conduct. It's going to get worse. The government's first witness, Detective Claimer, testified that she downloaded the CSAM using law enforcement's version of peer-to-peer software from the user of IP address that connected to the car lot on May 14th and 15th. The jury learned that the IP address was assigned to the defendant's car lot. HSI Faulkner testified about the interview of the defendant during the search of the lot on November 8th, 2019. We heard a lot about this. We knew this was coming. We knew the government was going to use the defendant's own words against him. As he explained, the defendant asked him unprompted, "What is this about? Has someone been downloading child pornography?" Well, if you're on the jury, are you like, is that really where your mind goes first when the feds are coming to your car lot? Not like money laundering, not like theft, not like have I been stolen from, not like a credit card scheme. No. Nope. The first thing that's asked is, has somebody been doing really awful shit here? Weird. The jury then heard clips of the interview in which the defendant said the desktop computer on the car lot was his, and peer-to-peer software and something related to the onion router, Tor, also referred to as the dark web, were on the computer. He knew it was partitioned, and he knew that Tor was on there. The jury also heard from the director, Director Fortall, who testified that the computer's hard drive was divided into a partition running the default Windows operating system that would boot up automatically, and a partition running a Linux operating system that a user had to take affirmative steps to access. The director explained that the Linux partition was created on May 13th, 2019 by someone physically present at the defendant's computer. The defendant's experts conceded this fact on cross-examination. Someone had to be hands-on to the computer to install the partition. If I say download, I mean install. I mean the same thing. But to install the partition on the computer, you had to be physically present to partition the hard drive. The director also testified that the Windows partition contained work material and an internet monitoring software known as Covenant Eyes. If you want to know more about Covenant Eyes, it's in my other videos. Well, the Linux partition contained the Tor browser bundle and the uTorrent peer-to-peer software, but not Covenant Eyes, which does not work on Linux, which they had a representative from Covenant Eyes come and testify to. The Tor browser and uTorrent, two programs that the defendant said were on his computer, were only installed on the partition. If it's only installed on the partition and you know that it's on the computer, then don't you know that there's a partition? Reasonable inferences. The Covenant Eyes representative explained that the defendant could bypass the internet monitoring by using Linux. The jury then learned that the username on the Linux partition was Dell1 and the password was Intel 1988, which was not the same password to the Windows side, but was one that the defendant had constantly used for years. Just a note. Use different passwords for everything. not just from a basic security standpoint, but they were able to say, look, this is his password for his social media account, or his this or his that. Are you giving your employees that password so that somebody else can use it? If that's your one password that you're using for all your shit? No. Reasonable inferences. And as other witness explained, the defendant had long been curious about the Linux operating. He was Linux curious, y'all, and partitioning hard drives to bypass programs like Covenant Eyes. Covenant Eyes, by the way, is a software monitoring for like anything you look at the computer. And then his partner, who heard all the things he was doing on the computer, was his wife. Okay, this is the yuck shit. The director explained that someone repeatedly downloaded the images to the Linux partition using Tor and uTorrent on May 14th, 15th, and 16th, including, I don't even want to say this, including files with titles like 14YO Girl, Suck and FUCK, and Pedo Mom, and 2 PTHC Ultra Hard Pedophilia New. The files that we previously listed were downloaded using uTorrent, which is a multi-step process. Typically, the user would first have to find the torrent files associated with the videos, in which case the titles revealed what they were, and would then use the torrent files to download the videos via uTorrent. The defense expert agreed that these titles would be evident to the person downloading them. You would see the titles. You would see the titles of the video. You would see the title. The director also testified, and the defense expert agreed, that these 2 videos and 5 others, all which depicted minors engaging in explicit conduct, were played on the partition after being downloaded at different times. And that the user of the partition navigated to folders and viewed the images in thumbnail format as well. The 2 experts agreed that the only document on the Linux side was a payment record from the car lot. Director Fortall testified that the images and messages from a backup of the defendant's iPhone on his laptop, images taken by the iPhone and saved in Apple's proprietary format EXIF, the metadata including GPS coordinates of where the iPhone was when the images were taken, and then how he did that. And it said, based on his review of the images and messages, the director testified that the defendant was by or at the computer every time the CSAM was downloaded and accessed on May 14th, 15th, and 16th, as well as when the document with his name on the Linux partition was created. So they took his phone, which geotagged when he was sending things or taking pictures, and said he was at the lot here, geotagged. His phone was geotagged here when these things were happening. This evidence satisfies the elements of the offense. Agreed. Hard agree. Hard agree. Hard agree. There's a footnote. Despite the director's testimony that he reviewed photos that were taken on an iPhone, defense expert claimed that the metadata was unreliable because she did not know if the defendant took the images on his iPhone or if they were taken with another device and sent to his iPhone. The defense expert later admitted that she could have determined whether they were taken on the iPhone, but did not, right? Because they have the access to the defendant and to his shit. She could have determined that, but chose not to, which is probably why the jury didn't love the defense expert based on the reports coming out of the courtroom. As the court observed, contrary to her representation that she starts with the facts and follows them to a conclusion, Ms. Bush knew the conclusion that she wanted to reach and took and looked at the possibilities to back into that, and was not permitted to offer her speculative testimony on this topic. So the court said no. The defendant next asked the court to overturn the jury's verdict to order a new trial, and then say that the defendant, then they get into the defense. Sorry, I hate I hate this motion so much, but it is what it is. And look, there's no way to look at one motion without the other. The defense is saying, I get a new trial because of all of this, and no reasonable jury could have found this. And the government's like, are you fucking joking me? Here, you want us to put, okay, here we go. Here we go. Here we go. Here it is. This is what the jury considered, and this is what the jury knew. And you're not getting this overturned on acquittal because there is ample evidence that this is the dude that did the thing. And then we're getting into the next arguments. The defendant was not precluded from calling Caleb Williams as a witness. The notion that Caleb Williams committed the offense is pure fiction. Is pure fiction. A story advanced by the defense for the sole purpose of casting blame, regardless of the evidence to the contrary, on a sex offender. I mean, you can understand why the defense might want to do that. But that person's prior conviction aside, the documentary evidence shows that he was elsewhere. I should have brought my face roller or like a emotional support pet. They say defendant now claims he's entitled to a new trial because the court precluded him from calling Mr. Williams as an alternative perpetrator witness. I'm sure Mr. Williams is thankful that the court did. A review of the record reveals the opposite. The court allowed the defendant to call Mr. Williams to develop this theory, but simply limited his ability to introduce evidence of Mr. Williams's prior sex offense pursuant to the federal rules of evidence until he established a non-speculative nexus between Williams and the crimes, which is like the law. The defendant's true complaint appears to be that he was limited from impeaching Mr. Williams as a sex offender prior to establishing the relevancy of his testimony. Right. Because the defense was hoping that that prior conviction would be so prejudicial against the witness that they'd be like, ooh, maybe that guy did it. That's what they were hoping for. But you can't do that. There's rules. Society and trials have rules. Rules! Defense's dissatisfaction with the court's analysis under Federal Rule of Evidence 403 regarding the impeachment of a witness fails to establish, quote, a miscarriage of justice sufficient to warrant a new trial under Rule 33. I agree. But it would be an interesting analysis if you are in law school and want to look at this analysis of when you can impeach and when you can't, and establishing, like a basic foundation, establishing relevancy, your basic steps to bring a witness in. This is an interesting way to do that. They said that faced with the certainty that he could not establish the nexus needed to trot out the witness's sex offender status, the defendant elected not to call him. Again, that's trial strategy. His failure to call Mr. Williams was therefore a strategic decision made with counsel, not a limitation imposed by the court, and his motion should be denied. I agree on that part. The defendant's decision not to call Caleb Williams as a witness, we've gone over that. We knew that this was coming. They went over this in the motion in limine. We knew. The court's ruling on Caleb Williams did not entitle the defendant to a new trial. Agreed, and we're not going through the government's analysis on it because I've already gone over it enough. They're talking about the government's Brady requirement that they turn over evidence in a timely fashion. The defense argues that the emails from Caleb Williams violated that obligation. The government is saying, first of all, it's not relevant. Second of all, it's not material. Third of all, we turned it over. The government has no duty to disclose evidence that is, one, neutral, speculative, or inculpatory, two, available to the defense from other sources like Duggar. The other source would be Duggar. How would they have the text messages between Caleb Williams and Josh Duggar? Ask Josh Duggar to give them to you. He's your client. Three, not in the possession of the prosecutor, or four, over which the prosecutor has no actual or constructive control. So speculative is where we're leaning on this. They go on to say that that Williams was not identified as a possible suspect or witness by law enforcement, that the agent explained at trial throughout the entire course of the investigation, through all the witness interviews, witness statements, and more importantly, forensic examinations, Caleb Williams did not come up. The person who was in the best position to know that Caleb Williams existed in the world and had been engaging with Duggar in the days leading up to this is Duggar. And you guys, I see you guys asking for DEFCON red. I don't think these motions are fuckery. Like, DEFCON red is what the fuck. I think these motions are really well written. That's why I'm overruling the DEFCON red, because though the facts are awful, these motions the motions aren't fuckery. The motions are just good motions. So that's why. That's why I don't find this to be a what the fuckery. This is standard operating procedure. Yes, there's more detail than we had before. Yes, that detail is gross. But there is not fuckery afoot in these motions. These are good motions. These are attorneys doing their work. And so for that is why I don't think these motions are fuckery. I think this is good motions being written and unpleasant facts that we are all now more aware of. My throat is like, what are you doing to me? I know. I don't know. My humidifier has started being very loud, so I turned it off for the live stream, but it really does help when the weather is so dry. It's weird how dry the air can be with the torrential downpour outside, but still. They're saying that Williams's name first came up on November 10th, a few weeks before trial, when the defendant identified him. When the defendant said, maybe this. Mm-hmm. When the defendant identified him as an alternative perpetrator in his response to the government's motion in limine. And we went over those. The defense later told the court at trial that they had been trying to speak to Mr. Williams for months, but had been unsuccessful. I wonder who was trying to speak to Williams, which raises serious concerns about the defense claims that he was a viable alternative perpetrator and further underscores the merits of the government's request to exclude this speculative theory. I wonder who was trying to talk to him. I wonder who was trying to get in touch with him. Was it the defense attorneys? Was it members of the Duggar family? I have questions. I have questions. After the defense manufactured an unfounded insertion of Mr. Williams into this case, law enforcement spoke to him and his attorney. This dude had to get an attorney by telephone on November 16th, 2021. And then Williams gave them the information, went to the Apple store, provided documents to verify his statements. We went over those emails in the defense motion. And they're saying, look, this is backing up what he said. Let's see. And they go on to further explore that, but we've already explored that pretty thoroughly. Repeatedly, the defendants reoccurring claim that the government's case hinged on the secrecy of Intel 1988 was the cornerstone of the prosecution's case. They're saying that that's a red herring. It's a red herring. It is a theory crafted by the defendant in hopes that the government would adopt it so he could present evidence to the contrary. The government did not take the bait, but instead introduced at trial evidence showing that the defendant shared the password with others, including his father and former vice president candidate, Paul Ryan. What? Oh, okay. Okay. What? The court noted the same, responding to the defendant's efforts to reshape the government's theory of the case by recalling some evidence that he was sharing this with a vice presidential candidate. Shit just gets weird. In its closing, the government made clear, explaining that this case has never been about the secrecy of the password. It's the habit the defendant had of using it. It is worth noting that on the morning of December 6, 2021, in the middle of trial, the defendant raised this alleged Brady violation with the court, and then they go through what the defense went through in their statement as well, saying that this other person, Williams, said that he had some of the other Duggar kids' passwords, which seems like it's irrelevant. The government did not violate Rule 16 or the Jenks Act. This is going into the demonstratives. Specifically, defense complains that the demonstratives show that someone could input Dell_1 username in Linux and install uTorrent using Linux's quote-unquote app store, and then asserts that this disclosure violated Rule 16, presumably because his expert testified incorrectly about these facts. So it's rebuttal witness. And the reason it came up on rebuttal is because the defense expert said you can't do that. And then the government called their expert to say, well, actually, you can. Let me show you. So that, again, is demonstrative that came up, it sounds like, because of the defense expert's testimony, which the defense failed to note. The defense expert, however, heard the director provide the exact same information in the government's case in chief, so it was already testified to. The demonstratives are irrelevant. I understand the court's ruling more clearly. because I don't assume that this is inaccurate. That the defendant now claims was only disclosed through the demonstratives and that it had no impact on her testimony. Nor do the demonstratives, which are essentially screenshots of a computer screen, meet any definition of a statement under the Jenks Act. Accordingly, the defendant's motion for new trial should be denied, and we're scooting past that because, again, it's a screenshot of the computer that reiterates testimony that was elicited on direct and then used in rebuttal. So, again, I agree with the court. On that. More context was helpful there. The director's testimony was appropriate and properly noticed. The defendant last asked the court to order a new trial based on what he claims was the director's impermissible expert testimony regarding EXIF information from the iPhone. The director testified that he reviewed the EXIF information on images taken by the iPhone for GPS coordinates showing where the images were taken, which he then plotted using Google Maps. The defendant claims that this constituted expert testimony, that the director was not qualified to opine on this topic, and the government failed to notice the expert testimony. They're saying the defendant's mistaken on all counts. First, the case he relies on to argue that the plotting of GPS coordinates from images metadata constitutes expert testimony, U.S. versus Crawford, is inapposite, meaning it doesn't apply. In Crawford, the court found that testimony about geolocation information sourced from an email address to historical Wi-Fi access points provided by Google required expert analysis. To be sure, other courts addressing similar cell data have ruled differently, because it's cell data, which is different than Wi-Fi data. But in any event, the director's testimony had nothing to do with interpreting third-party Wi-Fi access points or cell tower data, which is very much specific and different. He testified that he found GPS coordinates in the EXIF information. If y'all don't know how much information's in the EXIF information, I will bring someone in to talk about it if you're interested. There is so much information in the EXIF information on your phone and on your photos on your iPhone. Know how much information there is in there. And if you haven't, look at it. And there are, I might just bring somebody on to talk about it because I think it's really important to understand. And there is one YouTube creator I have in mind who would kind of be perfect for that tech conversation. That might need to be a bonus collab. All right. Anyway, found the GPS coordinates in the EXIF information of the images taken by the defendant's iPhone and mapped out the location of the coordinates as he has done for years. The court observed, Director Fortal was testifying about what he rationally perceived through a commonly used technique during his forensic examination, which any of us could do, by the way, and therefore offering an opinion on a topic within his personal knowledge under FRE 701. Again, anyone can do that. You can look at the EXIF on your phone and map it on Google. The expert testimony comes in with the accuracy of the EXIF information, and that was part of his forensic examination because he did the forensic exam. The director explained that the metadata in the image saved in Apple's proprietary format contains reliable GPS coordinates showing where the image was taken, that he commonly uses this information to establish location, and that he has used other sources to verify the accuracy of the data reviewed in this case. The defendants claim that the government has taken opportunistically inconsistent positions on the reliability of this data reflects, at best, a misunderstanding of the case law on which he relies. They then go on to continue arguing why that's accurate and saying that the government noticed geolocation information from digital photos taken by the defendant as a potential subject of expert testimony, which we all could foresee. The government will move to dismiss count 2 of the indictment at sentencing. As I have said repeatedly, count 2 is a lesser included. But just in case anyone would like to understand why you can't be sentenced on both counts in this case and why the maximum sentence is, 20 years and not more, we will get into it one more time from the AUSA's mouth and not mine. The defendant last instructs the court that it must dismiss count 2 with prejudice if it denies his other request. The court already addressed the relevant precedent, explaining that double jeopardy attaches at sentencing. That means that's the timing. You do it at sentencing. And that the government is entitled to charge the defendant under 2 different theories for the same conduct and to determine after the jury has rendered its verdict on which count the defendant should be sentenced. Here's a reason they're going to pick count 1. Count 1 has a floor and a ceiling. Count 1 has a minimum mandatory sentence of 5 years and a maximum of 20 years. Count 2 does not have a minimum. So they're going to pick count 1 because count 1's the greater because it has more time, because at a minimum, the least the court can do is 5 years. Consistent with its prior representation, which the defense previously agreed with, the government will move to dismiss count 2 of the indictment at sentencing. You can't be charged on both. It's a lesser included. We all know this. For the foregoing reasons, the government respectfully requests the court deny, blah, blah, blah. The defense opened the door in their motion in an interesting way, arguing that the government had to prove that Duggar viewed the images. That is not what the government had to prove. These were receipt and possession and knowing what they were, which is why the government took the opportunity to share the names of some of the files that left it unambiguous what the files contained. A jury makes the determination of fact if those file names are going to give a reasonable person, not a reasonable person, if those file names would have given Duggar the heads up of what was being downloaded. And the jury's allowed to take that in context with everything, with partitioning the computer, with downloading Tor, with downloading uTorrent, with going to multiple sources, to going to lengths to download these. Why would you do that unless you knew what they contained? And a jury is allowed to make those determinations. So the defense will file their reply. I imagine that the court will give us a very thorough breakdown of their ruling and that these motions will be denied, that the count 2 will be dismissed at sentencing, that sentencing will happen on April 5th, and that he will be sentenced. I am optimistic in the 8 to 12 year range. I don't think we're going to get much higher than that. I would be very interested to see the pretrial sentencing report, which we will not get to see because it is sealed. But there will be sentencing memorandums, and I would like to see what the government's going to ask for. So between now and then, we are going to see the government's position on sentencing and the defense position on sentencing. So there is still more motions to go before we get to sentencing on this case. I will be interested to see what the court does with that. I've also seen a lot of questions on social about Duggar attending some kind of a wedding or some shit with family members. I will just, and I don't normally comment on stuff outside of the court because A, it's not what I cover regularly, and B, I don't care. But here's the thing. With that, Duggar could have gotten permission because he was on detention. He had limitations on that pretrial detention. And with that, he could ask for permission for other things. I assume if he attended a wedding outside or not outside of what he was allowed to do, that they would have made the appropriate motions to pretrial services to ask permission to attend that. There would have been a breakdown and that would have been allowed by pretrial services. He could have been permitted to do that. If he wasn't permitted to do that and they had known, they would have yoinked his release and thrown him into custody, which they did not do. So that is my assessment on that based on what we've seen. It is, oh my God, it's almost 3 hours. All right, we're going to do questions. I have questions. You have questions. Me, hopefully we can get to this fast. Also me, not a fucking chance, but at least we're thorough. Let's see. Let's get to questions. I have questions. You have questions. We have questions. I'm going to try to get to some of the super chats too. I know that was a whole lot. I think context matters. I think context matters in going through both motions together, because otherwise it's like, well, they said this and they said this. It's nice to be able to do the two together, because then we see the defense is saying this and the government is saying this, and it's going to fall. We need the context, because the defense is like, they didn't say it, and the government's like, it was in his direct testimony. And it's like, well, that changes things a little bit, but that's the part of motion work that matters. And that's why when we talk about when we talk about trials, when we talk about cases, when we talk about motions, and we talk about lawsuits being allegations and shade, there are two sides to everything. And in lawsuits, each of those sides are written to put the side that's writing in the best light. So that's what it is. That's what it is. I don't see any of this getting granted except for the lesser included. Let me go to the super chats. Everyone who joined, I saw a couple of you join as members. Thank you. Question, what does the Fed guilty verdict today for the McMichaels means? I haven't gone and looked at the civil rights verdict, so I can't tell you. I don't know if it tacks time on to what they're already serving, but I will go look. That's the potentiality, because there was a federal civil rights violation in addition to the state prosecution, but I can get to that on Friday. I haven't had a chance to look at what the time is on that particular violation, and I do not know off the top of my head because I've been doing this. Jess, Emily, thank you so much for covering very difficult topics in a calm, logical, respectful way. I love being a law nerd. You're welcome. These charges are horrible. They are. This side, the child side of criminal law, was something I really tried to avoid. I was like, I don't want to do it. I struggle to be, I hate it. I know I hate it. I struggle with it. Everyone who prosecutes this kind of stuff struggles with it. It's fucking awful. And it is hard work to do for the investigators, for the prosecutors. This was hard, I'm sure hard for the jury, for the court staff. These kinds of cases are very difficult, but they are very, very needed. I very, very much preferred fraud. I was like, ooh, we're money laundering. Fascinating. What's going on? Fraud schemes. Because it is a different way to prosecute crime, and because financial crimes, though they are very hard for victims to financially recover from, it's different than crimes like these. And this is very, very hard. But I don't think there's any way to cover this other than with the solemnity it deserves. But that's also from, over 15 years of being an attorney, where there's more information here, but it's not tea. It's not like, oh my God, did Jen Shaw threaten Stuart Smith? Like, what are they saying in this motion? Like, are they going to use Real Housewives in her trial? It's not that. This just isn't that. This is so much, this is just so much worse than that. So it just needs it. And it's, we need to talk about it though, because these are things that if you're not in this world of prosecution, or if you're not paying attention to these cases, that you might not know the way that these things go on and how frequently they do. And I think that's an important conversation to have. And I will continue to have them, even though it's hard. And even though it's just, bleh, it's awful. And unfortunately, I can it's so real when you've done this work. It's just awful. And there's times I get asked this a lot, and not as much anymore, I guess, but like, oh my God, what's the worst case you prosecuted? What's the worst thing you've seen? It's like, nope. You don't want to know. You don't want to know. You don't want to know. And there are things that just will never be said, because there are things that are so awful that they can't be discussed. And that's part of something that prosecutors carry around. I know law enforcement carries it around too. It's something that people carry around. It's something that victims carry around. It's something that victim advocates and social workers carry around. It's something that therapists carry around. This is stuff that you carry with you. And knowing that allows for, I think, to be able to cover this with a little bit of humanity, or a little bit more humanity, because you just know. So that's what it is. I'm going to get to a few super chats. KH said Dave Head here too. Yay. Harry Sutherland said, you're an amazing human. I mean, I try. We continue just working. We continue working through all of what humanity throws at us. Humaning is hard. Adulting is hard. these last few weeks have been particularly hard. In this case, I'd been putting off covering it because I was just like, Devlin said, so happy for the live to get hubby and I through this bone marrow transplant. It's his happy rebirthday. Love you, Law Nerds. Oh, Devlin, good luck to you and your hubby. Bone marrow transplants are so hard, and we are thinking of you and sending you healing vibes. Dusty Blevin said, damn the ticket man. Yeah, damn the ticket man. Save the live music. Damn the ticket man. Cassiopeia Crow, that says Crow. I can't, oh, there we go. Said, I used to work in the secondary ticket market. Do not recommend ever. So anything not pre-sale bought, I get nervous about it being secondary bought, paying for a scalper rather than the actual venue. Totally fair. It is pre-sales hard. Sarah said, it's right up there with the fees on cable and phones. That's a whole nother day, isn't it? It's a whole nother day. Narco ASA said, remember in the 90s when Pearl Jam and the others testified before Congress about the Ticketmaster Ticketron merger was creating a monopoly and they allowed it anyway. It's gotten insane. It has gotten insane. Julia Blair said, just flew out of Nashville last week, ate breakfast at a restaurant just to hear the live music. Love it. I was so thrilled with live music at 9 a.m. Love Nashville Airport. I know. I do too. Having Nashville Airport as my home airport and not LAX makes me happy. Makes traveling a little less anxiety producing for me. Zen NGO said it's Two-Step Tuesday, so celebrate we will because life is short but sweet for certain. Two-Step is one of my favorite songs. Cameron Helms, thank you for the super chat. SJ Fountains, thank you for the super chat. G-Dash said, any chance you will file a motion to Wendy Williams' case to unseal the information as a podcaster or provider of news, copy paste their Second Circuit. Will I hire an attorney to do so? Because I do not practice there and will not be filing one on my own. I will consider it. I hope somebody does. Carrie Sutherland said, why did the jurors in the Maxwell case need their own attorneys? I'm very confused about that. Oh, just the one who's at the heart of all of this chose to get their own attorney. And I'm not surprised they did because the shitstorm that swirled after they gave that interview was very large. And I think they're that juror 50 is trying to make sure that they don't get in a whole heap of trouble. So having an attorney in that circumstance, I think is completely appropriate. So I think it's completely appropriate. Janice said, thank you for covering awful cases like Maxwell and Duggar. You're welcome. I'm sure YouTube appreciates it too. I appreciate the super chats because YouTube does not appreciate it at all. But it's needed. It's educational content, YouTube. Amy, hello, lady. Just wanted to say thank you for taking the time to help and read the article. It's great. I know you've been dealing with a lot lately and truly appreciate you. Thanks for all you do. Well, Amy, you're welcome. And thank you for being a law nerd. Elizabeth said, oh my God, I left a half an hour ago to get my fingerprints done to be a substitute teacher. And you're still going. Uh-huh. Still going. What should Brittany name her memoir? Is It's Brittany Bitch too obvious? Because I feel like it should be It's Brittany Bitch. But maybe that's too object. Maybe that's too obvious. Susie said, we survived the grossest shit. We did. We survived. We have all been personally victimized by Regina George this evening. No, if this hadn't been argued by Duggar's attorneys, which again, they are doing their job. And I just want to emphasize that I don't see anything Duggar's attorneys doing as outside of the realms of doing their jobs. And there have been times when I've seen motions from attorney and I'm like, what in the ever-loving fuck are you even doing? Like this, no, never, no, stop it. The attorneys on this trial have done their work. They have done their work well. They have presented their arguments. They are doing their job. And I have no shade for them. I think Duggar's defense attorneys have probably had quite a lot of access to money to do the extent of motions that they've done, but they've done their job. I don't see any of their motions as being frivolous. Some of their arguments have been a bit of a reach, but what else are you going to do? That's your job as the defense attorney. Make the motions. And I think the government has always responded in kind. There's been little bits of snark and shade, but not a ton. And I think that the motions have overall been really good. Better than some of the other cases we've covered. Hello, Seychelles Green. I hope I pronounced that right. As a mandated reporter, CNA, the things you are taught to watch for and when you encounter it is traumatizing. Can't imagine investigating it. Look, secondary trauma is real. It is real. It is very real, and it is hard. And it's something that I hope to continue to discuss as we talk about these cases, because I feel for the jury in this case. I really do. I feel for the jury. We went through a fraction of what this jury went through. Will they ever tell their story? I don't know, because they're probably feeling it too. Brittany memoir, want a piece of me. I like that too. I like that too. Let's see. Thank you for covering Brittany, Dawn, and Shalene. You're welcome. We're going to be getting back to Shalene. It's been on my list, and every week I'm like, we need to get back to. There's so many things we need to get back to it, for sure. Question: are the victim impact statements going to be from his 5 molestation victims or the victims depicted in the CSAM? If there was a victim impact statement that is sealed with regard to the sentencing report, it is really speculation, but it's my educated guess that those will be from any of his hands-on acts, because tracking down the actual victims that are depicted in the images is generally not done. Sometimes these images are old. Sometimes those victims are not still around. It's generally going to be from someone who's had other contact with him. I have never seen a CSAM case like this where it's not the creation of, where we hear from the children that are depicted in those images. If there are victim impact statements given in court, then we will know who they are given from, unless that part of the proceeding is sealed. I am very tempted to go down to those proceedings, and I'm going to see if I can make the timing work out. I mean, it's just down in Arkansas. What is the point of living in the middle of the country if we can't go the places? So thank you for that question, Pink Jinx. I appreciate that. Thank you, Emily. Yes, we could absolutely do some more thumbs up to let YouTube know that this is educational content, and they should let people see it. They're not going to want to, but they can. Let's see. Piece of Me is still such a bop. It is such a bop, Ashley. It is. I think Circus would be appropriate too. Jamila, I love this conversation. Maybe we should do this for Court of Public Opinion. Should we do this for Court of Public Opinion Friday? What should Brittany name her memoir? Toxic's also a good fit. I feel like this should maybe be our COPO. I feel like I'm making a note. I feel like that's our COPO for Friday. Thank you for asking. I think we should do that. We should have all the law nerds input on we're like, welcome to my circus. I think we should. What Britney song title or lyric should be the title of her memoir? That is COPO. That is all right. That is why not? I must confess. I mean, that's a good one too. Just the sister shade. Just the sister shade. All right. We have decided this will be the COPO for Friday. I have to decide on topics for Friday. I honestly, this Duggar case is exhausting. It's exhausting because when cases make me angry, the parsing of the emotion and going through the documents just takes more energy for me to moderate my own internal anger. So I don't like kid cases. They are very, very hard. I'm very protective of my own children. It brings up a lot of cases that I've had to do, and relationally, and it's hard. It's just, they're hard. And it's why I try to group the Duggar coverage together. It's also why I do not wallow in Duggar coverage. It is tremendously sad. It just makes me sad. So pronounced Shields. Perfect, Shields. It's German. Don't apologize. Don't ever apologize. I ask because I don't know. And I'm terrible at pronouncing things. And that's why I ask, never apologize. my maiden name is German because my dad's side of the family is German. My mom's side's Italian. My 23andMe was very interesting. I was like, y'all, I got some questions. I'll tell 23andMe stories another day though. Drive Me Crazy is also a fantastic option. I do not have an update on Peter. I hope that his husband will do an update, but I have not been on Reddit. I don't know if the Good Judy's Reddit or his book club on Facebook have updates. I have not seen any updates. Can you touch on Toddy, business partner? We did on Friday, and I will look and see if there's anything new, but I will. COPO, not just, I always put the vote up on the Twitters, and I put them up on the community tab on the channel. I always do both. Oh, I like All Eyes on Me too. You guys are great. You guys are fantastic. So with Kim saying, if you see Amy, if you seek Amy, I love that. So yes, I touched on Toddy. I think you'll have to go look in the timestamps. I think I touched on it Friday. I'm pretty sure. So they said Duggar checks all the enhancement boxes in his pretrial offer. What does that mean? It means that he's not going to get a departure downwards. So I didn't see a pretrial offer because there was an email. There really wasn't a pretrial offer. There was an email discussing it. I covered that email twice, and off the top of my brain, I'm not going to remember it exactly, but I covered that email twice. It was the attorneys talking back and forth about, look, he kind of fits there's no need to downward depart below the 5 years or more. And they said, we see it in the 10-year range. So when we talk about that it means they're not going to, they're not going to mitigate downwards. We'll see what they say in their sentencing memo, because that's really what's going to matter the most. But that's the attorneys were talking together saying, look, there's nothing particularly redeeming here. And in some cases you see it. I've tried cases where you look at it and you're like, there is so much on both sides that I can see why we would downward depart in consideration of these things. So they're saying, no, there's not really much redeeming to downward depart. And I get it. Ooh, this is a good one too, Sister Babylon. Stronger than yesterday. I love it. We're going to have to cull a bunch of these for COPO because there's a lot of good suggestions. I love it. So with all of that, I appreciate you for being a law nerd. I appreciate you for being here. I appreciate you for enjoying our new 3-hour stream. Really what we do now. It's starving. Any new Triller Klein stuff or any update on the judge leaving the case? I will do a Klein update on Friday. I haven't looked. So it will be in my roundup unless there's something big to cover. It's just been a lot of law happened. Like I want to do a deeper dive on the crypto couple. I want to look into the OpenSea NFT hack. There's now a lawsuit on that. I want to cover the ice skaters and the NBC and everybody getting sued for playing a song during the Olympics. Like there's so much. So there's so much. There's so much. And that's what it is. Emily, any hunches on what his sentence will be? I want to see the sentencing memo, but it's got to be at least 5. I'm hoping for the 8 to 12 year range. That would make me happy. I'm above the minimum would make me happy. Federal sentencing tends to be lower than expected for me. And again, I was a state prosecutor, not a federal prosecutor. I always look at the federal sentencing and go, it's a little low. I did not see it is your birthday. Happy birthday. I can't see the icons unless I'm on YouTube, unfortunately. Have you watched Adults Adopting Adults? I have questions. I haven't, but I keep getting asked about it, and I feel like maybe I need to watch it and do an I Have Thoughts episode of it. Zeneb, yes. It has been hours. That's how these things go. We talk for hours. Anyway, I've wrapped up like 4 times. Y'all, I'm going to go get some lunch. I hope you do too. I hope this finds you well wherever you are and you didn't spend hundreds of dollars in Ticketmaster fees today. because you can't say no to your summer plans to go see the Dave Matthews Band like me. I hope that you have a great rest of your day. I will have a new episode of The Emily Show up for you tomorrow on Wednesday. What did I talk about tomorrow? I forgot. What's tomorrow? Hold on. What's tomorrow's episode on? I'm going to go look because I have it in here and I want to tell you, and I've completely forgotten. Let me see real quick. What did I talk about? I don't remember at all. Oh, I do remember. The Russ wrongful death lawsuit. That's tomorrow. I've not blocked it from my mind. The Russ wrongful death lawsuit is tomorrow's episode of The Emily Show. So if you are ready for that, then we will see you and we will go from there. So Stronger made it through the circus. Ooh, also a great one. Also a great one. All right. So tomorrow, new episode of The Emily Show on your favorite podcasting app. It's ready for you bright and early in the morning. The video will premiere at sometime tomorrow. I haven't set that up yet, but I'll get to chat with you. It'll premiere at sometime tomorrow. And then I'll be back on Friday. I'll probably go over in the member sections and ask what you guys are looking forward to hearing on Friday. It'll probably be a quick bits episode without a deep dive just due to exhaustion. And I really hope we have an update on Peter from his husband soon. So still sending out love and thoughts. I need to roll the outro and go. And if you guys try our sponsor today, tag me on social and let me know what you think. It's fun. It's been taking a lot of my time. I really do enjoy Switchcraft, and I thank them for sponsoring this episode because, you know, the YouTubes are going to get cranky, and I'll probably just turn off monetization on this episode so I don't have to fight with YouTube about it, because that's why we have sponsors. All right. Thank you all. Thank you for being here. Thank you for being a law nerd. Have a good rest of your day. Stay safe. Bye. Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel,